Good afternoon. I know it's a little bit late, but it is March 26th, Wednesday afternoon. The Agricultural and Natural Resources Subcommittee is now in session. Mr. Clerk, if you'll open the board, members can log in. We'll give him just a second. I do believe they did us a favor by moving us over here because it's about 6 or 8 degrees cooler than that other room. Mr. Clerk, please take the roll.
Mr. Chairman, you have 8 members present. You have a quorum.
Thank you for that. Representative Fritz, if you would, lead us in the prayer and the pledge. If you all would, please stand.
If you would, bow with me. Dear Heavenly Father, Creator and King of all glory, we ask for your hand to be on these proceedings. We thank you, God, for the blessings you've provided us in Tennessee. We thank you for how you've blessed our fields, our rivers, our forest, God. You have so abundantly poured it out upon us. And I just ask, God, that I and those of us in here will serve you. Give us wisdom, give us discernment, help us to be the men and women you created us to be. And I pray that in Jesus' mighty name. Amen. Attention, pledge, salute.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you all for being here today. I know we've got a lengthy calendar. We're going to do our dead level best to get through this thing today and every bit of it. Before we start off, the intention is to give every person on the committee an opportunity to ask one question of any witness and then one follow-up, and then we'll go to the next person to try to keep things moving on so we don't get hung up on a back and forth on small technical terms. Chairman Todd, you're recognized.
Thank you, Mr. Chairman. I move House Bill 1099 and 1397 to Special Calendar 37.
Without objection, move to the Special Calendar 37. Do we have any other personal orders? Seeing none, let's get right into the calendar. Well, here comes Tyler. We'll let him give us a words of wisdom. And I will tell you this much, guys. It's been a busy day in this place. There's been lots of folks running around, doing different things, meeting in different corners of the rooms. So, Tyler, you're recognized for a few words of wisdom if you got them.
Good afternoon, everyone. Once again, I'm stealing these words of wisdom from your father and his personal proverbs by Jack Rills. Striving for success without work is like trying to harvest where you haven't planted. Y'all have a great afternoon.
Thank you for always having us something, Mr. Tyler. First on the list, we have House Bill 667 by Chairman Terry. We have a motion and a second. We have an amendment. Chairman Terry, does the amendment make the bill? Would you like to put the amendment on the bill?
6219.
That's what I have as well. So without objection, let's vote to put the amendment, motion on the amendment. Second, we have a second on the amendment. All in favor of putting the amendment on the bill, say aye. Any opposed? The amendment has been put on the bill and you're recognized on the bill as amended.
All right. Thank you, Chairman Committee. And as we're facing a solid waste issues in Tennessee, and in particular in the central Tennessee area, we're looking for information and alternatives on how we can address this problem. So this bill creates an advisory task force on solid waste to examine and review issues related to solid waste. The task force shall focus its examination and review on innovative processes for the disposition of solid waste and shall review all aspects of the disposition of solid waste that the task force determines to be necessary, including but not limited to landfilling, recycling, agricultural uses, incineration, and energy production.
You've heard the explanation of the Chairman Terry. Do we have any questions? I know we have 2 witnesses that have willing to answer questions, but I see no reason to bring them up. Without objection, we'll be voting on sending House Bill 667 as amended to the full committee. All those in favor, vote aye when the board opens. All those opposed, vote no. Mr. Clerk, take the vote.
Mr. Chairman, you have 8 ayes, 0 nays.
Without House Bill 667 on the floor.
Thank you, Chairman and Committee.
The number 2 thing on our agenda is House Bill 1149 by Chairman Butler. We have a motion. We have a second. And I believe you have an amendment as well.
That is correct, Mr. Chairman.
Does the amendment make the bill?
Yes, Mr. Chairman, it does.
Does it make the bill or amend the bill?
This one pretty much makes the bill.
Does it rewrite the bill?
Yes, sir.
Okay. Just making sure you know what your amendment does. Thank you.
Wrote the amendment.
Would you like to put the amendment on the bill?
Please, sir.
We have a motion on the amendment. Have a second on the amendment. All those in favor say aye. Any opposed? Give me the drafting code, please.
6467.
That's what I have as well. So without the amendment is on the bill as amended. Now
Thank
you
you,
recognize on the bill as amended.
Thank you, Mr. Chairman. This legislation will do two things. The first section outlines and directs in working with the Department of Revenue to track the sales tax revenue that is generated by the paddle sports industry to be used in some future legislation in potentially how we would refund TWRA or restructure some things. And then the second thing that it does, it establishes a usage fee that TWRA and the paddle sports industry has come to an agreement on for 42 cents every time a kayak or canoe is put in the water for the commercial paddle operators. And this money would be used for TWRA to maintain the ramps and so forth and to provide those services. And so with that, Mr. Chairman, I'll renew my motion and be glad to answer any questions.
Representative Fritz, you're recognized.
Thank you, Mr. Chairman, and thank you for the bill. Just one quick question. Would you consider this a new tax or a new fee?
You're recognized.
Thank you for the question. I don't know that it's necessarily a tax. This is an agreement between the paddle sports commercial operators and TWRA to generate revenue to help offset the cost of maintaining these ramps. I'm sure everybody in here knows what a load of gravel costs that they use on these ramps and the other services that are required. And so this is the paddle sports operators in good faith coming to TWRA to offer some revenue sources to try to help cover these costs.
Now, Chairman Butler, I believe that the paddle sports are now using these ramps currently and they're not paying anything. So this would be a fee that they would be using to help maintain.
That is correct, Mr. Chairman. They have come to the table to try to make a contribution to these ramps to help support the infrastructure that we've got. They are currently using it at no cost. And so they've come to the table to help provide funding for these.
Okay. Any other questions? Seeing none, then we'll be voting on sending House Bill 1149 on to full committee. All those in favor vote aye when the board opens. All those opposed vote no. Mr. Clerk, take the vote.
Mr. Chairman, you have 6 ayes, 2 nays.
Bill carries on to House full.
Thank you, Mr. Chairman and committee.
Third on the list, we have House Bill 747. Representative Fritz, we have a motion. We have a second. You're recognized on the bill.
Thank you, Mr. Chairman. I have an amendment that rewrites Bill 4659.
That's what I have as well. Would you like to put that amendment on the bill?
Thank you, Mr. Chairman. I would.
All those, we have a motion on the amendment? We have a
I'll
second.
I'll second.
We have a motion and a second on the amendment. All those in favor of putting the amendment on the bill, say aye. Any opposed? The amendment goes on the bill. You're recognized on the bill as amended.
Thank you, Mr. Chairman. Just for full clarity on this, I understand that this was general subbed in the Senate today, but I think it's an important enough topic for us to talk through on this bill 747. Energy, we're in an energy emergency in these United States. And if you will recall, colleagues, 2 years ago, we, by House Joint Resolution 119, decided we're going to have an energy policy in Tennessee. And last year, House Bill 2118 restructured our State Energy Policy Council so that we would have appropriate subject matter expertise on that council to be able to advise government on operations. This is the third part of that. It does a couple things, really, and I'll go through a brief explanation and then take any questions, Mr. Chairman, you all may have. The first thing it does is we have currently, our State Energy Policy Council administratively reports, if you will, and I think I've got that terminology correct, to the Comptroller's Office. This bill would restructure that reporting to both TDEC, mutually to TDEC and ECD. Certainly, if there's anything that's economic and community development, it is energy. I think it's the single most commodity that we need in today's America, in today's Tennessee. I would offer to you all that we're more dependent upon energy in all sources, from electricity to diesel fuel and gasoline, than we are on water itself. Because without those sources of energy, we indeed have no water, we have no sewage, we have no gas supplies. It's important for us to stay focused on this. Given its criticality, it's imperative that we as a state not only plan for effective and efficient ways to meet our current energy demands, but develop a comprehensive vision for the state of Tennessee and strategies for meeting the energy needs and demands of the future. This council leverages Tennessee's abundant subject matter expertise from all segments and skill sets of the energy industry across our state, enabling a comprehensive policy suggestion to be formulated for the benefit of the General Assembly and for the Executive Department. In addition, it positions Tennessee to better lead the nation in nuclear power generation. Part of Oak Ridge is in my district. We have the Oak Ridge advantage here in Tennessee. Small modular reactors and perhaps even Watts Bar 3s and Sequoia number 3s at some point in time are technologies that we are well versed in the state of Tennessee. But we've got to look for bridging mechanisms to get us there, Mr. Chairman and committee. And that requires us to take, I think, an all hands on deck and an all of the above approach. I think this committee does that. This bill also structures a reporting mechanism so that this information from these committee meetings can be sent in to TDEC and ECD, and TDEC and ECD can help to formulate those strategies for our governors and for the General Assembly. I would offer that there is a significant fiscal note on this bill. It has been worked together. The good folks in TDEC and ECD come and spoke to me about that. It is about $800,000, and it's for staffing to make sure that we can invest in this energy structure in the state of Tennessee and lead the nation. Again, we're fortunate that Governor Lee is putting money into our nuclear energy and trying to keep us in the forefront. But I can assure you colleagues, for somebody who's been around that part of the industry for some time, we have other states that are going to fight hard and put lots of money into beating us to the punch on being the uranium technology center. Tennessee must maintain that. It's good Tennessee jobs. It keeps our lights on. It keeps our water flowing. And with that, Mr. Chairman, I'll take any questions y'all may have and ask for your favorable consideration.
Do we have any questions of Representative Fritz? Seeing none, we'll be voting on sending House Bill 747 on the full committee. All those in favor vote aye when the board opens. All those opposed vote no. Take the vote.
Mr. Chairman, you have 7 ayes, 1 nay, 1 present not voting.
House Bill 747 on the full. Chairman Todd, if it'd be okay with you, I'm going to go on, catch me and you towards the end. So we'll roll past, we'll roll House Bill 896, 897, 803, 799 to the Hill. I'm going to take out of order now. I'm going to take item number 18, House Bill 1086 by Chairman Hulsey. We have a motion. You have a second. You're recognized on the bill.
Thank you, Mr. Chairman. Thank you, committee. I want to say first off that my bill deals with the state vet, but I want you to know something. I admire the state veterinarian a great deal. She's a very, very articulate lady. She's very, very smart. She does her job very, very well. And I have all the confidence in the world in her. My issue is not with the state veterinarian. My issue is with the law. We promised and swore that we would uphold the Constitution of the state of Tennessee. I'm trying to deal with some way, to find a way to be constitutional with the way the law is written, dealing with the latitude that the state veterinarian has. And for an unelected person, and not even a law enforcement officer to require a warrant, but to go on property and mandate testing and mandate vaccines. And this bill, all this bill says is you can't do that without getting approval from the government ops first. But it got defeated in the Senate. And again, I have all the utmost respect in a state vet. I want to fix the law. I want to be constitutional. That's who I swore an allegiance to. So I'll be back next year. I appreciate your indulgence and thank you, Speaker, Mr. Chairman, for letting me talk on this for a minute, but I'd like to take the bill off notice.
So without objection, we'll be taking House Bill 1086 off notice.
Thank you, sir.
Thank you, Chairman. I'm looking to see who all's in the building here. Let's go back to item number 11, House Bill 1137 by Chairman Boyd. Chairman Boyd, you have a motion and a second. You have an amendment, I see.
Thank you, Mr. Chairman. I do. It's Amendment Drafted Code 4107.
That's one I see as well. Do you want to does the amendment make the bill?
It makes the bill, Mr. Chairman.
Okay, we have a motion and a second on the amendment. All those in favor of putting House Bill 11, the amendment on House Bill 1137, vote aye. Any opposed? The amendment has gone on the bill. You are recognized on the bill as amended.
Thank you, Mr. Chairman, committee members. Over the last couple of years, especially after COVID-19, the number of TDEC employees in the field, I think, was reduced a little bit, and development has grown in Middle Tennessee. It has taken a lot longer to get septic permits on single family homes with 750 or less gallon capacity. And so, what this bill would do is it would require TDEC within 10 days of receiving the documents from a soil scientist to approve or deny the septic permit. It's pretty simple, Mr. Chairman.
You've heard the explanation. Representative Martin, you're recognized.
Thank you. Chairman Boyd, what happens if this doesn't get done in 10 days?
You're recognized.
Mr. Chairman, there is no teeth in it. It just simply directs them. It puts it into statute. And it's kind of consistent with some of the permitting legislation that we did in the previous General Assembly. It kind of brings the septic permitting online with that. But I, as you and I had discussed, there's no hammer here. It directs them to do that, but there's no civil action or punitive assessment or anything like that.
Representative Martin, you're recognized. Any other questions? Representative Shaw?
Yeah. Ms. Sponsor, I appreciate the comments, and I know you talked to me about this the other day. I did want to ask you, though, what, in case of emergencies, we know anything, especially we just had COVID a year or so ago, a couple of years ago, something like that were to take place where they just couldn't get to it, what do you think this legislation would do to the department?
You're recognized.
Thank you, Mr. Chairman. All we can do is attempt to hold them accountable. There's no teeth in this legislation. I mean, if it gets to be a problem or we see they're not compliant, then we would come back and I maybe would put some teeth in it. But at this time, and I do want to do a little shout out for TDEC. Since we've had a conversation with them and brought it to their attention, they've really stepped it up. And so a lot of the builders in my community have said, listen, seems like you've already fixed the problem. They're now being a lot more responsive. And I think that there were just a few isolated incidents that kind of rose to the surface and got the soil scientist sort of cued in on that and brought it to me and a senator's attention. So we did want to run this legislation, but I think they've already kind of proven that 10 days is very doable.
Okay. Well, I'm going to support you because I told you I would, but I am just a little bit concerned about them having to say 10 days because anything could happen. I'd want all of us to be reasonable. I'll say that. But thank you for your comments.
Seeing no other questions, we'll be voting on sending House Bill 1137 on the full. All those in favor vote aye when the board opens. All those opposed vote no. Take the clerk. Mr. Clerk, take the vote.
Mr. Chairman, we have 8 ayes, 0 nays, 1 present not voting.
Okay. Congratulations. House Bill 1137 on the full. Next on our list, Chairman Boyd, we have House Bill 1139. That's your bill also. We have a motion. We have a second. I see no amendment.
Thank you,
You are recognized.
Mr. Chairman. Members, if you like good legislation, you're going to love House Bill 1139. So a constituent of mine had an apartment complex, and they live in one of the areas that has the hardest water from the utility in the state of Tennessee. And so to sort of benefit their tenants, they put in a point of entry water softener system. And somehow, and we don't know exactly how, but TDEC found out about it, and they now regulate them as if they were a public utility. Similar to how any public water utility it would be regulated. And even TDEC has admitted this is the only apartment complex in the entire state that they do this with. And so what this bill does is it simply states that if water is being treated for the purpose of just softening, basically a water softener system, that it does not constitute a water treatment plant and doesn't have to be regulated like so. And that's what the bill does, Mr. Chairman.
Any questions of the sponsor? Going once, going twice, sold. House Bill, if you're in favor of sending House Bill 1139 on the full, vote aye. When the board opens, if you're opposed, vote no. Mr. Clerk, take the vote.
Mr. Chairman, we have 9 ayes, 0 nays.
House Bill 1139 on the full.
Mr. Chairman, I do want to say, I believe this is my first time ever. It's my 8th year coming to the Agriculture Committee, and I just want to tell you that it's been a pleasure. You guys did not let me down at all. I appreciate
Well,
it.
don't be a stranger next year. Let's go back. We had to jump over Chairman Vaughn to get to Chairman Boyd, but we'll start back at item number 8, House Bill 543 by Chairman Vaughn. Wake up.
Thank you, Mr. Chairman. I got several items to take business to do with you today, so I was making sure I
Yeah, I
had the
got
right
you.
one. If I could, sir, I could get drafting code 6361.
That's what we have. Does that make the bill?
Yes, sir.
Have a motion and a second. All those in favor of putting the amendment 6361 on the bill, say aye. Any opposed? The amendment is going on the bill, and you are recognized on the bill as amended.
Thank you, sir. House Bill 543 is attempting to do two things. Two basic things. One is that if a municipality or sewer system has served an area outside its corporate boundaries for at least 25 years, then prior to them shutting off service to that area, they must come and present their case to the Tennessee Board of Utility Regulation. That way, it would be a situation to where anybody that was tied to that service would have ample notice to try to find alternative manners to sewer. The other is a simpler aspect of it, and that is if you have a gravity sewer line on your property that flows across your property and is an easement and there's capacity within that, then you should have the right to connect to it. And that's what 543 attempts to do.
Do we have any questions of the sponsor?
Mr.
Yes, sir.
Chairman,
You're
I would
recognized.
like to clarify that it's provided that it's not, can be proven that capacity is not there. So, if it's full, then you can't get into it. That's one thing. But if you can, then you can't be held out for other reasons.
Representative Martin, you're recognized.
Chairman Vaughn, thank you so much for this legislation. I can see how it's going to meet a lot of needs. But here's my question. I just want, just from a clarity point of view. So if I had a sewer that was north of that area, north of the municipality, and what you're saying is, and they've serviced that for 25 years, they can't deny that family or that home anymore. Is that correct?
That they can, but they would need to go to our Tennessee Board of Utility Regulation to make the case for taking them off.
Okay. What about if there was a neighborhood or something that was built in between those two areas that had maybe been there 10 years? Are they just out of luck, so to speak?
You're recognized.
What the bill contemplates, Representative Martin, is that it's because if a city was to do this, I would have to think that it's either a strategic decision for them, a management decision, something along those lines. What this is contemplating is more of a region, because typically sewers are in interceptors, which are larger pipes that everything feeds into, and that's kind of how they manage from that. What this attempts to do is say, hey, you can't valve this off and not provide this service anymore if you've provided it for this long and leave all these people high and dry. There's got to be a case made to the Board of Utility Regulation to do such a thing.
You're recognized. Good. Any other questions? Seeing no other questions, we'll be voting on sending House Bill 543 on the full committee. All those in favor vote aye when the board opens. All those opposed vote no. Mr. Clerk, take the vote.
Mr. Chairman, you have 9 ayes.
House Bill 543 on the full committee.
Thank you, sir.
Next on the list, House Bill 541 by Chairman Vaughn. We have a motion and a second. You are recognized.
Thank you, sir. And let me say thank you to this committee for hanging with me on a long journey. This bill is seeking reforms in the isolated wetlands portion of our code. TDEC regulates isolated wetlands as waters of the state, regardless of its benefits to the environment. All water impoundments, including tractor ruts, clogged ditches, feedlots, and roadside ditches, are treated the same as high-quality wetland ecosystems such as Reelfoot Lake or Ghost River, along the section of the Wolf River in West Tennessee. The objective is to bring our laws into alignment with other states and many of our border states that do not regulate isolated wetlands. As it stands today, we have, in my opinion, one of the most progressive liberal regulatory environments like one found in New York, Vermont, Oregon, and California. In 2023, the Supreme Court of the United States ruled that these isolated wetlands were not waters of the U.S., removing federal Clean Water Act regulations on them. And our original bill had sought to mirror the results of that ruling and put Tennessee on the same regulatory plane as our neighbors. Arkansas, Alabama, Georgia, Mississippi, South Carolina, Missouri, Kentucky, and 17 other states around the country. In 2023, North Carolina passed legislation mirroring my original bill, and now they no longer require a permit for impacts to any isolated or non-jurisdictional wetlands. Similarly, Indiana passed legislation last year to also scale back permitting requirements for these isolated wetlands. Now, today, this amended language greatly reduces what we were hoping to achieve. I was hoping for no regulation. However, last year, this committee approved a scheme where we were talking about limits of 5 acres and 2 acres. Well, we're talking about now a 1/2 acre and a 1/4 acre as opposed to 5 acres and 2 acres. So we've reduced the scope of what we're trying to do by 90% from last year. This amended, it also matches the thresholds that the commissioner of TDEC had proposed in a summer study regarding this. Now, that I don't think it goes far enough, but at least it's beginning. I had to stop and listen to myself the other day, and I found myself actually preaching to myself. I heard where I was talking on a podcast where I talked about the problem in this place these days is the fact that people aren't willing to compromise, that it's either win and be correct or take the loss. Well, I took a loss last year, and this year I decided I'd try to find something that was a little bit more palatable to the stakeholders in this area, and at least let it be a starting point. And last I'd say is any movement back in favor of the property owner is beneficial. And so I can go into the bill, but I'm sure there's other people talking. I know we've got a short deal.
I believe we have an amendment we need to put on the bill.
Yes, sir.
I have drafting code 6502.
So do I. I'd like that rewrites the bill. I'd like we could, sir, I'd get that attached because it's the bill in full.
Okay. We have a motion and a second on the bill. All those in favor of putting amendment 6502 on the bill, say aye. Aye. Any opposed? The amendment goes on the bill. And now we're back on the bill as amended. Do you have any statement you'd like to make before we bring up witnesses?
Well, I'd like to thank the folks who have been supportive of this bill. The Beacon Center, Farm Bureau, Tennessee Chamber of Commerce, the Home Builders Association of Tennessee, Build Tennessee, NIOP, the Tennessee Road Builders, and the Tennessee Soybean Association have all been helpful with this. And I'm sure that folks will have questions, and I know that y'all want to have people. I can stand up here and you know my passion for this, Mr. Chairman. I could preach all day about it, but if I understand the need to move along too.
I understand. It seems like Groundhog Day, just to be honest with you. All right. Well, without objection, we'll be going out of session to hear from some witnesses. So without objection, out of session. Can you please have, or will Miss Hillary Bonham, Mr. Cole Liggett, and Sarah Houston please come forward? And we'll just have, you each have 3 minutes to make an opening statement. And then when you get through, the committee will ask questions of you. And then you can go sit down. Ladies first.
Want me to kick this thing off?
Please.
All right. Well, thank you. Hello, everyone. My name is Sarah Houston. I serve as the Executive Director of Protect Our Aquifer. We are a nonprofit based in Memphis, Tennessee, but serve the surrounding counties as well. I'm sure y'all have enjoyed becoming wetlands experts over this past year, so I'm excited for that opportunity. But y'all likely know that the Memphis Sand Aquifer is a very important resource for West Tennessee. It is the source of drinking water, irrigation water, and industrial water as well. And when we talk about wetlands, those are the most efficient landforms in West Tennessee when it comes to rainfall, infiltrating into the ground, and resupplying our drinking water source. So if you think about the aquifer like a bank account, we need those deposits to match the withdrawals. And losing wetlands without mitigation will start to tilt that scale towards overdrafting. Now, there has been a long stakeholder process through this last summer. We were glad to serve on that and know that Chairman Todd was a big part of that. And we did have a stakeholder compromise that TDEC presented last fall. And unfortunately, this bill does not follow that guideline. Protect Our Aquifer has started to expand into these surrounding counties and Fayette, Haywood, Tipton. And we've heard from communities, how they want their area to grow with Blue Oval City coming in. This is an exciting time for West Tennessee. And we really want to, what we've heard has been very clear. They want their towns to infill. They want to see their rural communities come back, and they want to avoid sprawl. They want to keep that rural aesthetic. They want to keep the farming industry intact. And we're really concerned that this amendment has too many loopholes in it, like cumulative impacts, or removing cumulative impacts, removing riparian buffers, doubling stormwater detention, that we're going to potentially undo a lot of good that has helped with smart growth. And so what our wetlands laws do right now is it incentivizes developers to plan around wetlands. It keeps that rural aesthetic. It keeps that preservation, that the reason people moved to West Tennessee in the first place. So when it comes to cumulative impacts, bear with me on a nerd thing real quick. When it comes to cumulative impacts, what is that? That is when we looked at a specific parcel. We just kind of pulled up an example near Collierville. It was 150 acres. There were about 10 and a half acres worth of isolated wetlands that were under 1 acre. The way that this amendment is drafted is you can't add those up. So it's kind of like death by 1,000 cuts. Those could all be paved over, filled in, no mitigation required. And so that would be saying goodbye in that specific example to 230,000 gallons of deep recharge. That would say goodbye to recharge, our rural aesthetic. And these are the kind of issues that we have with this amendment. This doesn't quite get to the stakeholder compromise we had last year. So we absolutely appreciate Chairman Vaughn. He has come a long way from no regulations at all. So we do acknowledge that. But we just can't support HB 541 as drafted. And we ask that y'all play a role in supporting smart growth, smart protections, and ensuring that West Tennessee can really continue this legacy of rural conservation and wetland recharge. Thank you.
You're recognized.
Good afternoon. My name is Hillary Bottom. I'm with Betis Restoration Partners, and today I hope to add some context as both a developer and a mitigation banker. My family first moved to Middle Tennessee in 1808 from Virginia. My grandfather got into residential development in the late 1970s, and my father, Bob Goodall, began building homes in 1983. In Tennessee, we've built over 15,000 homes. I personally was responsible for developing 8,000 lots in over 40 communities. In many of these communities, we had to mitigate for the impact to our environment. As developers, you fight a lot of things, the not in my backyard sentiments, permits and costs. Yet developers are accustomed to mitigating for their impact on the community, whether it's through traffic impact fees or school impact fees. What mitigation impact fees allow is for stormwater management and to prevent the ramification of flooding. So we think about long-term gains over short-term cost wins. I first learned about mitigation credits back in 2017 in a residential community up in Sumner County, where we just couldn't avoid the environmental impact of a crossing. The accessibility of mitigation credits allowed us to get our permit more quickly. And furthermore, I believe being able to avoid wetland or stream mitigation or being able to offset those with mitigation credits creates better communities. Today, the stream industry has about 130 approved or pending mitigation banks in Tennessee that will be affected by this bill. And mitigation banks actually support development by forecasting for mitigation, investing in bank development to meet the demand in order to provide permitting efficiency for developers. Although often viewed as a burden, the mitigation industry is a large supporter of the development community. We firmly believe in the necessity of development and actively participate in it ourselves. At the same time, we recognize the immense value of preserving functional and beautiful natural resources which remain essential to our communities here. The difficulty in acquiring mitigation credits for developers and impactors is largely attributed to the high barrier in approval for a mitigation bank. I naively thought coming into mitigation banking that this would be a much easier process than the arduous development process I had to undergo for home building communities. But just like a development project, there's an acquisition process, an entitlement process, and a lengthy development process, whereby a mitigation credit provider takes on market risks of supply and demand driven or reduced by an area's growth. Unlike the residential projects I've worked on in the past, which can be phased, restoration projects are often completed at one time and left to recoup the costs over 7 to 10 years at great market risk. Currently, wetland credits average $50,000 a credit in Tennessee. With fewer wetland banks providing credits in the future, it's likely that the remaining credits will be exponentially more expensive when they are needed. For example, Georgia does not regulate isolated wetlands, solely depending on the federal regulations like Chairman Vaughn shared, which increases uncertainty and risk, driving up costs. According to the Georgia-Alabama Land Trust in lieu fee program, wetland credit prices range from $750,000 to $1.1 million, 15 times our own. Well, I appreciate this body's ability to effort to establish consistency. I would urge you to reconsider this bill.
You're recognized.
Good afternoon. My name is Cole Liggett with Headwaters Reserve, and today I'm representing the Tennessee Ecological Restoration Association. Greatly appreciate the opportunity to speak today, and thank you for your consideration. As a fourth-generation Middle Tennessee cattle farmer and avid outdoorsman, I recognize the value of our natural resources and the importance of protecting them for future generations. Professionally, I've spent more than a decade supporting the development industry as a consultant, and I've also developed stream and wetland mitigation banks across the state of Tennessee. Mitigation banks require significant upfront investments prior to the ability to sell credits. Prior to a mitigation bank being approved for operation, the bank owner must legally and financially commit to acquiring the property, fully implementing construction, and managing post-construction for at least 7 years, regardless if they ever sell a single credit. It is a high-risk industry. For comparison, imagine a 500-home residential development. This would be similar to the developer legally and financially committing to purchasing land, building out all 500 homes, and then managing those homes by mowing the yard, trimming the hedges, fixing leaky faucets, and changing light bulbs for 7 years, regardless if they ever sell a single one of those 500 homes. Changes in regulations such as jurisdiction, impact thresholds, or removing cumulative impacts increases the risk in the mitigation industry, which in turn affects current and future mitigation development. Cumulative impacts play a significant role in being able to forecast supply and demand of mitigation through an understanding of consistent regulatory processes. Tennessee state wetland regulations have historically proven to be a steady hand for economic growth in the state, providing consistency for both the development and mitigation industries amid the continually changing federal regulations that have changed working on 11th change in 10 years. Decreased regulation and permitting inconsistencies increases the uncertainty and risk for the mitigation industry. More than 80% of state regulated wetlands is estimated to potentially be lost as a result of this legislation, which equates to approximately 80% decrease in the demand for mitigation. Such a drastic decrease in the demand after such a high investment on the front end has potential to drive up credit prices as a necessity to avoid potential financial insolvencies for a $1 billion mitigation industry and growing in the state of Tennessee. While we greatly appreciate Representative Vaughn and the body's efforts to improve wetland regulations and associated permitting processes in the state, we believe this legislation as currently proposed could have unintended consequences for both the development and the mitigation industries. Thank you again.
You had 15 seconds to spare. Do we have any questions of the witnesses? Seeing none, thank you so much for coming. We have three more. Mr. George Nolan, Mr. Ryan Jackwood, and Mr. Jared Manning. We'll have the same protocol there. You each have 3 minutes, and we'll shut your mic off when you get just a few seconds over. You're recognized.
Thank you, Mr. Chairman. My name is Ryan Jackwood. I'm the Science Director for the Harpeth Conservancy, and I have a PhD in ecology with almost 10 years working on wetland issues. I wanted to talk about a couple specific aspects of the bill. going to start at definitions. I'm not going to go all the way through, but I'm just going to touch on definitions. The definition of artificial isolated wetland is incredibly broad in this legislation. It will likely result in an unknown number of wetlands being categorized as artificial when some provide the same benefits as natural wetlands. There are a few places in the state that have not been directly or indirectly impacted by humans, so it would be tough to determine which wetlands formed as a result of human impact. We also know from Dr. Murdoch's research at Tennessee Tech that young wetlands less than 5 years old exhibit benefits similar to established wetlands. Age doesn't necessarily align with functionality, so the 5-year limit doesn't mess with known science. Defining low, moderate, and high quality wetlands, as this bill describes, can also be a challenge because there will be some subjectivity within those definitions. Representative Vaughn mentioned Indiana. Indiana passed a law a few years ago that similarly defined wetlands into 3 categories like this. According to folks in Indiana, they are seeing disputes and appeals over the specific classification of wetlands. So if they're seeing that a wetland's being delineated as low, there might be appeal dispute trying to get it to high or vice versa. So there's some discrepancy in how they are classified. I want to talk briefly about the commissioner having the ability to unilaterally change wetland size and mitigation requirements. It's problematic for several reasons. The amendment only allows the commissioner to increase minimum size. What if the current or future commissioner determines that the size limitations are too high, or that the ecological sensitive places in the state, like America's most biodiverse river, the Duck River, deserves more protection? Allowing minimum acreage amounts to be changed also creates confusion and uncertainty within the mitigation and development sectors who routinely rely on these numbers to stay consistent and transparent so they can efficiently navigate the permitting process. And I will leave it there. Thank you very much.
Good afternoon, ladies and gentlemen. My name is Jared Manning, and I'm an environmental scientist, geologist, and wetland scientist. I'm based out of Brentwood. I work at Aquitaire. I come here today as the voice of actual boots on the ground experience, and a lot of the states that I've heard thrown about as like examples of what we want to try and either equate or achieve. I have performed environmental assessments in wetland delineations, wetland work, wetland assessment, wetland permitting in all the lower 48, every state. I have extensive experience with states that have tight, strong, good wetland regulations, and they abide by a set of rules and principles. And then I've dealt with states that have kind of foregone wetland protections and eliminated any kind of cumulative impact thought. The states that have done so at a cost. Like, for example, Texas, there's 254 counties in Texas. Every one of those counties has experienced a federally funded flooding disaster. In multiple of those counties have experienced multiple federally funded flooding disasters. Iowa, 95% of their wetlands are gone. Iowa invests a lot of state-funded, budgeted money. A subcommittee gets together and funds water quality control wetland programs to rebuild the wetlands they've lost. So they destroyed something, replaced it with a developed thing. That developed thing was destroyed by an event. Then they're rebuilding the thing that was, so it's just this wild round robin circle. My main experience comes in the form of like understanding chemicals of concern and how they migrate through water and filtering those processes out in wetland delineation work. We're entering into like a fine line, and it's a dangerous, precipitous place to go with chipping away slowly but surely at wetland regulations, at water rules, to eliminate the cumulative impact, which Tennessee, which I have delineated over 100 delineations in Tennessee. I've been to wetland areas all over the state, and I've yet to encounter a truck rut or a hog pen as a wetland, but I find that there's a number of places that if these rules go through, the wetland protections put in place, the mitigation required to offset the loss, all of these things, they lead to like Tennessee's going to enter the race to see whose rivers catch on fire first. And that's just not a place we want to go to. That's not a pathway that we're trying. We want these states to follow our lead. I'll leave it at that. Thank you.
Thank you, Mr. Chairman. My name is George Nolan, and I'm a native Tennessean. I'm a cattle farmer, and I'm also an environmental lawyer, and I'm grateful to address this committee. I am genuinely concerned that we are about to break something. For the last several decades, Tennessee law has protected our state's wetlands and provided developers with a financial incentive to avoid destroying wetlands when possible. During those same decades, Tennessee has experienced tremendous growth. Yet now this committee is being asked to remove important protective guardrails and to turbocharge the pace of development during a time when Tennessee is already the 8th fastest growing state in the union, and we are losing farmland to development at a rate of 10 acres an hour. It's not really fair to characterize this legislation as a compromise, because last year, TDEC conducted a summer study about wetlands at the direction of a Senate committee. TDEC facilitated a robust stakeholder process that culminated in an all-day wetlands summit at the Elmington Ag Center, and upwards of 100 people attended that gathering. And those stakeholders included multiple state agencies, developers, mitigation bankers, universities, nonprofits, and several members of the General Assembly. And those people invested hundreds of hours participating in a discussion about how we should regulate our wetlands. And I think maybe part of the problem with the specific language of this bill is that neither of the sponsors of the legislation intended that important gathering. And this amendment goes way beyond what TDEC recommended. First of all, it allows developers to destroy wetlands of up to an acre in size if they're low quality without any mitigation requirements. And the reason that's such a big deal is that 80% of our isolated wetlands are less than an acre in size. So what you're voting on today is to authorize developers to destroy up to 80% of our isolated wetlands with no mitigation required. And it also contains a really big loophole in that it no longer would require developers to consider the cumulative impact of all the different wetlands that are within their site plans, and would, in our respectful view, allow them to do fake math and kind of treat those wetlands as their own individual things when they build things out. And that will result in tremendous loss of wetlands that are not in any way offset through the mitigation program. So we just ask this committee not to change a system that has served our state so well for so long. Thank you for considering my thoughts.
Thank you, gentlemen, for coming today. Did we have any questions? I want to just say one thing. I know Chairman Vaughn has been working on this. One of the first 23, I guess it was, he was here, and he asked you, Mr. Nolan, you mentioned the comprehensive study with TDEC over last summer. Representative Vaughn went to TDEC 3 years ago and said, come work with me. They had a whole year to work with him, and they didn't work with him. And he worked last summer, and we passed some legislation that we were satisfied with in this committee. And this is not near, this does not go near as far as that legislation did last year. I would have been satisfied if he'd brought the legislation from last year personally, but just to put that on record. Do we have any other questions? Thank you so much. Thank you all for being here. Next on our list, we have Colleen Lindgren. I hope I said your name right. I don't know what I did.
Very close. Colleen.
You're recognized. You have 3 minutes.
Thank you, Mr. Chair and committee members. My name is Colleen Lindgren, Legal Policy Manager at Pacific Legal Foundation. PLF is a nonprofit public interest law firm representing clients free of charge in constitutional litigation. We have won 18 U.S. Supreme Court cases, all of which address the same issues that bring us here today: property rights and regulatory accountability. So I'm here today to ask for your support for House Bill 541. We thank this committee and the sponsor for attending to a critical issue for the last few years. And when addressing environmental regulations, we're dealing with property rights. And Tennessee is a leader in many ways in private property rights. For example, prohibiting rent control. And this is a great analogy for the issue we're talking about today. So that reform reflects the same principles. Tennessee recognized that rent control took away the right to rent your property for what you and renters believe it's worth, along with the benefits of a competitive market that encourages growth and improvement and innovative access to housing solutions. When governments restrict rental income or use, they're devaluing property and violating owners' rights under the Fifth Amendment. That principle applies here. This bill, as introduced, recognized that to regulate land for having water on it amounted to the government devaluing that land. And when the government devaluates land, it takes away property rights and should justly compensate owners. Pursuant to the Fifth Amendment's promise that individuals will not be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. As amended, this bill takes a step back from these first and foundational constitutional principles, and I strongly urge this legislature to understand this bill is now only a first step toward protecting private property rights in Tennessee, that further work is needed. As amended, the bill assumes the state has the authority to limit use of private property, and if the state wants to regulate isolated wetlands, it should justly compensate owners, recognizing that the people who are the state of Tennessee must bear the burden of this type of government interference. Otherwise, some are receiving a benefit at the expense of others. So this is bad practice and, more importantly, unconstitutional. And Chairman Vaughn already mentioned the 2023 U.S. Supreme Court case where the Supreme Court decided in favor of PLF's clients, Mike and Chantel Sackett, whose property was tied up in over a decade of litigation due to its mere proximity to water. So this is an example of how wetlands regulation, however well-intended, can be abused. Where precious environmental assets are in need of true protection, it's incumbent upon the government to do so in the way that is least burdensome to individuals. It's not always, I should say, it's probably never an easy needle to thread, but nonetheless, it has to be done. Rights guaranteed by the Fifth Amendment are no less important than those guaranteed by the First or Second or others that we're all familiar with, but limiting the use of private property does just this. So with that in mind, we recommend the passage of House Bill 541 and encourage the legislature to continue pursuing constitutional reforms that respect Fifth Amendment protections for all property owners in Tennessee. Thank you for your time. I'm happy to answer any questions.
First on the list, we have Chairman Todd. You recognized.
Thank you, Mr. Chairman. You've probably answered a question, but just for reiteration, I'll ask it anyway. For private property owners that have land that all of a sudden has a wetland on it, it's determined to be a wetland, and that meets the current regulations and rules. Who pays those owners, those property owners, for that wetland, for that the lack of use of that wetland? When the regulations say you can't use it without spending a lot of money on it, who pays them for that? You're recognized.
My understanding at this time under Tennessee's law is that nobody pays them.
Chairman Todd, you recognized.
I would say you're exactly right. Also, I'm thinking you're probably familiar with our laws in Tennessee and the rules and the regulations. The things have been mentioned over the last year plus about flooding and flood mitigation. Do we regulate or otherwise control water quantity in the state of Tennessee?
You're recognized.
I don't know the answer to that question, but I'd be happy to find out and get back to you on it.
Well,
Chairman Todd, you recognized.
I can tell you we don't.
Okay.
We regulate water quality. 1972, this legislature adopted that policy, and that's been the policy from the beginning. But we don't regulate water quantity in the state. And I would argue that if we do, and I'd love your opinion on this, if we did regulate water quantity, then the state would literally control every inch of property in the state of Tennessee from the standpoint of what you can do on that property, how high you mow your grass, whether you can put a driveway in, whether you can put a house, anything and everything that deals with rainwater and the runoff therefrom. Would you agree or disagree with that?
You're recognized.
I'm not a scientist, but from a policy perspective, I think my understanding of the law in this space is that yes, if you regulated water quantity, you would be touching almost everything in the state.
Representative Jones, you're recognized.
Thank you, Mr. Chair. And thank you for being here today. Are you from Tennessee? And if not, can you tell us where you came from today to be here?
You're recognized.
Thank you. I work for the Pacific Legal Foundation. My office is based in Arlington, Virginia.
Representative Jones, you're recognized.
Okay. So you're talking about the voice of Tennesseans, and we had 6 Tennesseans, people who live in our state, tell us to not vote for this, and we have somebody come from out of state telling us what is in the best interests of our people. Are you aware that this bill does not include farmers and farmland? Are you aware that they're exempt under current legislation?
You're recognized.
Yes, but I don't think that doesn't change my perspective on property rights for individuals.
Representative Jones.
You brought that in your testimony. How did you get to be the voice of Tennesseans? Did you speak to farmers? Because we had some farmers here say they're against this bill. So do you have clients here? How did you get to be the voice of what Tennesseans want in terms of this legislation? Do you have clients here? Have you spoken to some of our farmers or people who have wetlands on their property? I'm just curious as to what leads you to be here today.
You're recognized.
Thank you. I don't claim to be the voice of Tennesseans. I think that in the experience that I have as an advocate nationwide in many states, and with the litigation experience that my firm has, we speak out for what we believe is best for individuals. In this case, it's for individuals in Tennessee, but my testimony is about what's best for individuals and to protect individual rights. And I think that includes Tennesseans.
Okay. Thank you for being here. You got 3. Thank you for being here. Without objection, we'll be going back into session. Chairman Vaughn, you're recognized for a closing statement.
Thank you, Mr. Chairman. I think we touched on something that really is what got me interested in this. And to my colleagues' issue, let's talk about farming. Our wetlands policy, farmers are exempt for the Clean Water Act. And so they don't have to have a permit to do what they need to alter any wetland. What happens is when the way that this system works is whenever somebody changes their intent, not the action that they're doing on the ground, because if I'm a farmer, I can go in and I can till up a wetland. People do it all the time. But yet the day that that property is sold to someone who has an intent other than farming, they have to pay a third party to use their property. That's what this bill seeks to at least begin to swing the pendulum back some. And I'm open for any questions.
Thank you, Mr. Chairman. Thank you, sponsor, for all the work you've done on this. I vote against the amendment because I'd like to stuck with what you had last year as well. But I appreciate the compromise. And do you think this is a favorable step forward for Tennessee rights?
You're recognized.
Yes, sir. It's a baby step, but it is a positive step. It, again, we've got to start somewhere, and I had to listen to my own self preach about compromise, and this is the way I digested it.
Thank you.
Okay. Representative Vital.
Thank you, Mr. Chairman, and thank you, Mr. Vaughn, for bringing this discussion to a head. All of us know very little about wetlands, but we've learned a lot, and we probably still have a lot to learn. I am deeply concerned about the unintended consequences of this action. We are talking about over 100,000 acres in jeopardy that are the sponge for our state. East, Middle, and West Tennessee wetlands are totally different. I know there has been enormous compromise, and I appreciate all the stakeholders who civilly have tried to work together to come to something that nobody likes now. That probably makes for a better bill than we had before. I don't consider this bill an environmental bill. I don't consider it a conservation bill. I think it's about the stewardship of the next generation of our land in Tennessee. I have great concerns about it. I can accept compromise. That's how we get things done up here. The cumulative impacts greatly concern me because they do work together. It's like a living being. The heart doesn't function without the lungs, and the lungs don't function without the liver. And so with that, you know where I stand. I appreciate moving this far, but I am opposed to this bill.
You're recognized.
Thank you.
Well, I appreciate that, and I appreciate the civil conversations we've had with regards to it. Reasonable people can disagree about these things. It's interesting, though, because when I hear from the folks that, particularly on the conservation side, and that is, we're going to lose all of this. These typically they're very large numbers, very alarming numbers, but there's no incentive to go out and crank up and start eliminating wetlands. What this does is this, for people who want to use their property for a certain purpose, this deregulates and eliminates the fact that they may have to pay a third party to use their own property. And that goes on in the farming and timber industry already. So I don't see, and those are completely unregulated, unpermitted. So in that instance, which is the bulk of the land, we haven't seen the disappearance of wetlands. The sponge hasn't dried up. And so what this is doing is this is trying to move the needle back. I have grandchildren. I'm a farmer. I had filmed one of the greatest episodes of Mississippi Outdoors. We were killing green-headed acre eaters on TV. I'm an avid outdoorsman. If I thought that this would harm our environment, I would not be a proponent of it. What I think this is common sense. My first incident with regards to wetland regulation was when I was representing a client, and I was hearing people say subjective things, and they would say, oh, if you had done this 2 weeks ago before you decided you guys were going to have a development application in, then you would have been exempt. You could have done what you're doing now, but now it's a violation. Why? Because there was a different intent in the mind. The action was still the same. That doesn't seem right to me. And so that's what I'm trying to resolve here. And I understand reasonable people can disagree, and I appreciate the civil debate that you and I have had about it. And I appreciate these folks here. I'm doing what I think is best, and they're saying what they think is best. And I understand sometimes people just don't agree.
Follow up with Representative Battle.
I would just say thank you for allowing these individuals to state their passion and their love for Tennessee. Thank you.
Chairman Todd.
Thank you, Mr. Chairman. A couple things I noticed in the testimony that we got. I heard about aquifer recharge that was different than what we heard last year from the same group. Last year, it was less than 2% of aquifer recharge comes from the very things that we're talking about here, that most of it actually came from upland ditches. That was information for me. That was really good information. And I understand they're actually redoing their model in West Tennessee about the recharge zone to account for that. Another thing I heard was protect our jobs. You know, I had some of these folks in my office earlier and their main point about this bill was we're going to lose money. This is how we make money. We've got a lot invested in this, and we heard that today. And I reminded them, same here. I do too. I've worked on these projects, and I've talked about some of those that I've literally done work on, erosion control and grassing. So this affects me negatively, but it's the right thing to do, I firmly believe. I would ask you this. I think you would agree that the current system we have with the strict controls we have on wetlands of pretty much any size would add cost. It does add cost to every house. Just about every house is built. It adds cost to shopping centers. It adds cost to our grocery stores. It adds cost to our roads. We've had this conversation before as well about just how much money our Department of Transportation has to spend on mitigation for these very things, isolated wetlands, that most people would walk up to and say, you mean I have to have a permit for that? Even members on our committee, I've heard them say things like that. So that's really the real world that we're living in today. I literally have a project that I worked on. There was a question whether it was a stream or not. And I did a stream determination on it. Determined that it was not a stream. It was a ditch. TDEC challenged that, did their own determination, says, well, it barely scores to be a stream. So we appealed that. We won the appeal the next year. And then they said, oh, yeah, you won that appeal. It's not a stream anymore, but it's a linear wetland. Literally had a little strip of wetland vegetation on each side of this poorly dug ditch. It was literally dug with a track hoe across a cornfield. And that determination, oh, don't worry, it's under a general permit. You'll hear talk about a general permit some. Don't worry, it's under a general permit. I bet it added at least $100,000 to that Amazon warehouse that was eventually built on that property. Every one of us gets to pay that has any packages coming from Amazon. That's just tacked onto it. This is not a developer cost. This is a cost to the end user every single time. And I would imagine you would agree with that, but you're in the development business as well. You help developers all over the place. So I'd love your opinion on that. Make sure I'm at least getting that right.
You're recognized.
Thank you, Mr. Chairman. I can give you some anecdotal evidence that for a client of mine in Collierville, and this is why the cumulative impacts is something that I feel very strongly about, is wound up with 0.29 acres of wetlands across a 65-acre field, which ultimately was going to have, no, excuse me, I'm sorry, it was 48 acres. There were 65 homes in it, 65 homes on 48 acres. And there were 0.29 acres of wetlands. And where they were found up against a drainage ditch that, again, on the farm, it wouldn't have mattered, but since the soybean field we bought and we're going to put houses on it, suddenly that was a resource that somebody had to pay somebody for. So we had a little drainage, side of a drainage ditch, had soybean terraces to where, because they're built to stop erosion and water stands up against it. And then the coup de grace was the county road had some cattails growing in it on where a pipe is, but the owner of the property didn't maintain it. But it was a situation where the property line extended to the center line of the road because it was an old country road. And so the county maintained ditch wound up costing that. And you say, well, what does that do? Well, when you go through the math on it, he had about $100,000 worth of cost on it. But as Chairman Todd has spoken, that's not the real cost. Because if you, in the residential development game, land costs are only about 20% of the total cost of the house. That's the way that appraisers work it. So for all you who don't know this, 5 times the lot cost is usually what the house is going to be. So if you looked at that $100,000 and multiplied it times 5, that's $500,000 that were going to be divided up among 65 end users. So it was somewhere around $7,500 a home that the consumer was paying for as a result of soybean terraces functioning properly, an unmaintained roadside ditch, and the side of a drainage ditch on a farm. And that's how this stuff works. That's who really pays the price for this.
Chairman Todd, you get one follow-up?
You were talking about the 0.29 acres. So what if it had been 0.24?
You recognize?
Then we would have been fine. And the environment wouldn't have changed. The economics wouldn't have changed. That was okay. And so that's what I'm saying. Some of the arbitrary and subjective matters. And all this comes down into to humans determining where these things are. And it's a game that definitely needs to be deregulation needs to come, but it needs to be simplified through plainer regulation so people will know what's expected of them when they encounter it. And I think this bill does that.
Seeing no one else on the list, so Representative Jones, you recognize?
Thank you, Mr. Chair. I can see where the wind is blowing on this bill, and there's a saying in Spanish, mala hierba nunca muerte, which means bad weeds never die. And so we know this is going to keep coming back up. And the thing that I'm seeing with this is that this is not about property rights or conservation. This is about everyday Tennesseans versus the power of special interest lobbyists on this hill. Every email we received from all across the state, and I literally did a tally, I printed every single email. I went through each one, was against this bill. The only people who came here to support this bill, you brought an out-of-state lawyer who doesn't even live in our state to say that this is in the best interest of Tennesseans. They gave us every argument. They said last year, this will increase flooding because 1 acre of wetlands holds 1 million gallons of water. If we ruin this, we'll see more flooding. We saw that argument. Then we heard about the cost on our recreation and our sportsmen. We heard them come. And then we had the farmers come. Then we had the environmental scientists come. We've had all these Tennesseans come. Even grandmothers just saying, I just wanted to make sure we protect the wetlands for my grandchildren. And so they've given us a scientific argument, the economic argument. They've given us the moral argument. And none of that will appeal because people have made deals here and the developers will always win in this. And I hate that because this is the only people who will profit from this bill are not Tennesseans, but it's putting more money in developers' pockets. That's who's going to profit from this. And so my heart breaks because I know what happens on this committee. I've been here long enough. And I just hope that one day when you have to answer to your grandchildren why the state looks like it does, why all the beauty of Tennessee that makes us want to live here, why we see more flooding in their communities, why they don't have access to clean water. I hope that we all have the right answer to my colleagues here. Let's let our legacy be one that's better than this, than just always bowing down to the special interest developers and lobbyists who fund your campaigns. Let's answer to Tennesseans, our constituents. That is my only appeal to you. I know where you stand on this. You know where I stand on this. And I know how the game plays here, where things are decided behind closed doors. This whole committee is, we bring witnesses. We bring one witness to say they're for it. who doesn't even live here, and that's who this committee is going to listen to. I know how this game works, so I'm going to sit down, but I know where you stand. I know that this is about giving more money to developers. We don't have to lie. Let's just be honest to Tennesseans about what your bill is about, because it's not about protecting Tennesseans or future generations or even their property rights. It's about profit, and it is wrong. It is wrong. It is wrong.
Was there a question in there?
My question to you is, what is your message to our grandchildren and children when they look at this committee and they see people coming here doing the people's business, emailing us, calling us, hundreds of, or even thousands of people saying, please don't do this. Please don't do this. And you have no one on your side, no Tennesseans from your side saying, do this. No one wanted to come and put their face on this because they know that's not in the best interest of our people. Where are the people? Where are the farmers and the Tennesseans who support this? We haven't heard an outcry from them. The only people you name are lobbying groups. I don't answer to lobbying groups. Maybe some others do, but I don't. I want to answer to actual people. And it's not about who's funding my campaign, but it's about who we are elected here to represent. And it's not a law firm from Virginia. It's the people in Bedford County, in Davidson County, in Murray County, in Hamilton County. And so what is your response to the people who've been pleading with us not to do this?
Chairman Vaughn, you're recognized.
Well, sure. What I'm going to tell my grandchildren is, hey, your grandfather had the guts to stand up for more property rights and more freedom for individuals, that we're not transferring our property to someone else just because they're able to paint a dreary picture about hyperbole about outcomes that may or may not happen. That's what I'm going to tell them. I'm going to say, you know what? We stood up for ourselves, and that's what we're going to deliver.
Seeing no other questions. Well, Representative Stinnett?
I was just going to call a question.
Question's been called. All those in favor of sending House Bill 541 as amended on the full, say vote aye when the board opens. All those opposed, vote no. Mr. Clerk, take the vote.
Mr. Chairman, we have 7 ayes, 2 nays.
Congratulations, Chairman Vaughn, on the full committee.
Thank you
House
very
Bill
much.
541. You are also the next bill, I do believe.
Yes, sir.
House Bill 612. We have a motion and a second. You're properly before the committee. I do have an amendment. Do you have an amendment?
Yes, sir. My amendment is
5569.
I can't even guess at that. Yes, sir. It is 5569.
Does the amendment make the bill?
It does indeed.
If I can get a motion on the amendment? We have a motion and a second on the amendment. All those in favor of putting the amendment on House Bill 612, say aye. Any opposed? Say no. The ayes have it. The bill has been amended, and you're recognized on the bill as amended.
Thank you, Mr. Chairman. And a few years back, with TDEC support on individual ARAP permits for wetlands, if you operated under a general permit, you were able to get up to 0.25 acres without mitigation being assessed. But if you did an individual permit for an area larger than that, what we did then was we said, okay, we don't start at 0. Let's say you had a 1 acre. You didn't mitigate the full 1 acre. That's the way the old rule were. But now it's like you get the first quarter that you would have gotten in a general permit anyway. And so then you go to 0.75. What this does is this expands it to stream mitigation as well. I'll tell you what got my attention. I don't even serve this area, but the town of Arlington in Shelby County, they're expanding a road, and the road was the permit was for 212 feet of alteration. Was basically they were putting a culvert in because a pipe had to go across the stream. For that 212 feet, under a general permit, if they could have gotten it to 199, it would not have cost them anything. But that extra 13 feet cost them over $500,000 in mitigation fee. So that's what we're talking about. So this community, as they begin to build out a road network to deliver fire services to other areas of their town that made shorter drives to schools for their parents, this small town had to come up with over $500,000 in mitigation expense. And so what this would do is this would have had them paying mitigation for 13 feet that exceeds the 200, or the 12 feet that exceeded the 200, as opposed to having to start at zero and pay the entire thing. And that is all the bill does, Mr. Chairman.
We have any questions? First on the list is Representative Martin. Okay. Question's been called on sending House Bill 612 to full committee. All those in favor of sending House Bill 612 to full committee, vote yes when the board opens. All those opposed, vote no. Mr. Clerk, take the vote.
Mr. Chairman, we have 8 ayes, 0 nays, 1 present not voting.
House Bill 612 on the floor.
Thank you, Mr. Chairman and committee.
House Bill 1072 has been sent to the general sub, and I've got an email asking it to be taken off notice. So without objection, we'll take House Bill 1072 off notice. House Bill 893 by Representative Bain. 983. We have a motion and a second. You're properly before the committee.
And I think I have an amendment.
What do you have?
Is it 3423?
I have the same one.
Great.
All right. Would you like to put the amendment on the bill?
Yes.
Does the amendment make the bill?
Yes.
Okay. Do we have a motion on the amendment? We have a motion. And a second. We have a motion and a second. All those in favor of putting the amendment on the bill, say aye. Any opposed? The ayes have it. The amendment is on the bill. You're recognized on the bill as amended.
Thanks so much, Mr. Chairman. Really excited to be here. I thought this moment and this bill could be a start of a conversation that I hope to have the next year or 2 years, I guess. So this bill I'm bringing forward is the Office of Rural Prosperity Act. It's a bold, coordinated, people-centered strategy to ensure rural Tennessee doesn't just get by, but gets ahead. I emailed you all, but a little bit about me. I was hired as a rural organizer in 2017 and organized across the state of Tennessee and Kentucky, and supporting rural communities, especially in some of the hollers, in terms of supporting them to engage in rural economic development. I then managed one of the largest rural organizing programs in the country. And then my current organization that I worked for before I ran for office had worked with states such as Wisconsin, Kansas, and Michigan to establish state offices of rural prosperity, acknowledging that rural communities have really unique needs, independent of just rural development and agriculture. And then in 2022, we actually worked with Senator Joni Ernst and Senator Mark Kelly to establish the National Office of Rural Prosperity, which didn't pass, was filed in federal Congress. So I think with that, rural Tennessee is not just about the Farm Bureau. It's not just about agriculture. It's not just about farmers, from my experience. And as I said, rural Tennessee is diverse and has a lot of unique needs. So this bill is designed to advance rural economic and community development across Tennessee. The legislation establishes the Office of Rural Prosperity within the Department of Agriculture to provide targeted investments, reduce regulatory burdens, and ensure that our rural communities have the resources they need to thrive. And with that, I would like to take this bill off notice so that I can work on it in the next few years. Thank you.
Thank you for your presentation. Without objection, this bill will be taken off notice. Next on our list, we have House Bill 130 by Representative Renew. We have a motion and we have a second.
Thank you, Mr. Chairman and committee. I do have an amendment.
What do you have?
6132.
6132. We have a motion. 6123. My dyslexia kicked in, excuse me. That's what you have too, right?
Yes, sir.
6123.
Correct. I might have said it wrong.
I probably said it wrong. We have a motion on the amendment and a second. The amendment makes the bill, correct?
Yes, sir.
So we have a motion and a second on the amendment. We'll be voting on putting the amendment on the bill. All those in favor, say aye. Any opposed? The amendment is on the bill, and you're recognized on the bill as amended.
Thank you, Mr. Chairman and committee. I'm happy to report that this Senate companion bill passed unanimously just a little bit ago. HB 130 is an expansion of the Food Freedom Act that was passed in 2022. And this expansion today that I'm hoping to achieve is that we would allow farmers or small producers a greater opportunity by letting them be able to also make homemade items that contain poultry and dairy. I have worked closely with the Department of Agriculture, and we have reviewed policies from 10 other states who also have similar food cottage laws so that we can balance food safety with the economic freedom that this bill will offer. We already trust our neighbors at potlucks, at gatherings, whether it's at our neighbor's home or with public events. And what we're asking with this is to acknowledge that we can also trust local food sales in the same way. By passing this bill, we'll give consumers more opportunities to purchase local food, and we'll give more small businesses the opportunity to thrive or to start in their home kitchen to test the idea. So with that, I'll stand ready for questions.
Representative Fritz, you're recognized.
Thank you, Mr. Chairman. Thank you for the bill. I just thought as you presented it that both my grandmothers are passed on now, but both of them would have been in support of this to be able to sell pies or cakes or whatever and enter the economy and practice something they love doing. So thank you so much for doing this.
Representative Jones.
Thank you so much, Mr. Chair. Thank you for bringing this bill. We got a lot of emails from family farmers supporting this, and so this is the type of regulations that we cut will benefit our family farmers. So I think there's bipartisan agreement that this is a really important piece of legislation. So thank you for bringing it.
Thank you.
You have a follow-up?
I just appreciate a yes vote. This is a great bill to increase opportunities for not just families, but farmers and for consumers.
Representative Vital.
Thank you, Mr. Chairman, and thank you for bringing the bill. I just want to clarify, this is dairy and poultry and not meat. Is that correct?
Correct. We did eliminate meat due to the potential impact on the future state meat inspection program that we're hoping to achieve this year.
Okay. And the including of these two items and home sales does not jeopardize any state or federal funding for the state.
Correct.
Thank you.
Representative Alexander, you're recognized.
Just wanted to make sure that the dairy is pasteurized.
It is pasteurized, yes.
Thank
The exclusions in the bill do specifically exclude raw milk, alcohol, fish, and shellfish.
Okay. Thank you.
Representative Shaw.
Thank you, Mr. Chairman. This young lady done worked me hard on this bill. I just thought I'd have a little fun, but she done worked real hard. I think she's been in my office about 5 times. And I told her that I wasn't going to support her, but I am going to support you, okay?
This doesn't count. This doesn't count the one payback.
But I did want to quickly say that sometime back, I don't know, because I've been on this committee for a long time, so sometime back before she became a legislator, she came and testified, I think, maybe on the same bill. I don't know the same bill or not, and whatever it was, I didn't support her. So I promised to today that I'm going to make up for it by supporting on this. But I just want to ask you one thing, and I'm sure I already know the answer. This is all by choice, right?
Yes, sir.
You're recognized.
Yes. Okay. Thank you so much.
Seeing no other questions, congratulations on coming to the committee and not getting beat up. House Bill 130, all in favor of sending House Bill 130 to full committee, vote yes when the board opens. If those are opposed, vote no. Mr. Clerk, take the vote.
Mr. Chairman, you have 9 ayes.
On to House full with House Bill 130.
Thank you, Chairman and committee.
Next on our list, look at there. I thought about voting no, Justin, Representative Jones, excuse me. Next on the list, we have House Bill 1325. We have a motion and a second. There is an amendment. Representative Cochran, do you have an amendment?
Yes, sir, Mr. Chairman. I've got drafting code 005831.
That's what I have as well. The amendment makes the bill. We have a motion on the amendment. We have a second on the amendment. Can we put the amendment on the bill? All those in favor of putting the amendment on the bill, say aye. Any opposed? The amendment's on the bill, and you're recognized on the bill as amended.
Thank you, Chairman and committee. I know there'll be some discussion on this one. We have some folks to testify, and so I'll just give a brief opening, and then we can get deeper into that discussion. But obviously our state has a very rich agricultural heritage, and we generate significant activity from that. And so that's been put at risk here lately. From 1997 to 2017, Tennessee lost 1.1 million acres of farmland. Tennessee is ranked second in farmland loss in the nation, behind Texas, with a projected loss of nearly 2.2 million acres of farmland or ranch land from 2016 to 2040. And so obviously our farm families are extremely important to us. They keep food on our tables, drive our economy, but we're losing about 9 acres an hour. And so this bill is the Farmland Preservation Act. It's an attempt to help promote and to incentivize our generational farmers to hold on to those farms so they can continue producing food and revenue for our citizens. And so with that, Mr. Chairman, again, I will yield to questions, but I believe we also have a few folks to testify.
Well, we have 4 people on our list to testify. Mr. John Avery Emerson, and we'll go out of session without objection. We're out of session. Mr. John Avery Emerson, Commissioner Andy Holt. We'll have these 2 gentlemen first, and then we'll have 2 more to testify after that. Well, since Andy's with the administration, Alex, why don't you come on up just to make. Andy Holt, a bureaucrat. We're out of session. Mr. Emerson, we'll allow you 3 minutes to make an opening statement.
Thank you, Mr. Chairman. Appreciate the opportunity.
Just to let everyone know who you are and who you're representing.
Yes, my name's John Avery Emerson. I'm a lifelong conservationist, a farm owner, and a longtime property rights advocate. I take note that the buzzword here is urban sprawl, which is not defined in this bill. If it's supposed to cure something, you need to know what it is you're going to cure. I would urge you to see this bill as a land use bill. It's a sort of a permanent zoning map that nobody can touch. If the Tennessee Municipal League came to the General Assembly with a request for cities to enact zoning maps that could never be changed, you'd think they've lost their mind. So I urge the committee, subcommittee, don't disarm future legislatures. First, don't make these easements permanent. That's a horrible mistake that puts us on a collision course with the future. Limit them to 10 to 15 years, maybe even make them renewable. Otherwise, you need to figure out a way to give landowners and the communities they live in some sort of termination clause. This will also enormously complicate any industrial recruitment and location. Second, don't hem in communities or counties without giving them the final say of approval for these easement contracts. You are effectively nullifying planning and zoning powers you have extended to cities and counties and other titles of the code, and none of this is in the caption of the bill. Third, don't pay 1 red cent to out-of-state NGOs and especially international NGOs. There's nothing in this bill to stop the money from going out of state or even outside the country, or to even stop speculation. Fourth, don't grant a cent to any contract that does not specify that the Chancery Courts of Tennessee have sole jurisdiction for disputes between landowners and NGOs. Disputes are inevitable, and the NGOs will come to your county with a carload of Wall Street lawyers and sue the farmer in federal court and bleed him dry. Fifth and final, make some sort of provision that if the wrong piece of property is put into perpetual development purgatory, the local governing body or the landowner has a local trustee vested with power to release the contract. This can be done if the state prohibits its funding for going to any contract that doesn't include this provision. Thank you, Mr. Chairman.
Thank you, Chairman and committee members. I'm Alex Lewis here on behalf of Governor Bill Lee. For the past 2 years, you've heard Governor Lee and other agricultural stakeholders talk about the alarming rate that we are losing farmland in Tennessee. Not only has the amount of farm and forest land that we've lost increased, but the rate of loss has increased significantly. For the 20 years from 1997 to 2017, we lost farmland at about 6.3 acres an hour. But from 2017 to today, we're losing farmland at 9.8 hours an acre, 9.8 acres an hour, pardon me. We've lost a total of 1.5 million acres. So it's vital for us to do something to help stem the tide. We could talk today about the 30 other states that have passed programs to incentivize farmland preservation. I could tell you that Pennsylvania passed the first law 35 years ago and the $1 billion that they've put into preservation. Or we could talk about our friends in Florida who, under Governor DeSantis's leadership, appropriate $100 million a year to their agricultural preservation program. But I really want to talk briefly about this program being a wise investment in supporting all of the other efforts Governor Lee and you all have made about agriculture. For the state, for years, the state has been investing in our agricultural future, including nearly $300 million through the Ag Enhancement Program since 2005. We have helped farmers innovate through dairy, genetics, hay storage and equipment, livestock equipment, and so on and so on. And I know that Deputy Commissioner Holt can speak immensely to that. We all succeed when they succeed. And so additionally, we are proposing updates to the state's meat inspection program so that we can see more freedom come back to Tennessee's livestock producers. We're also investing in the next generation of farmers through 4-H and FFA. Those young people were here just a few weeks ago to celebrate Ag Day, and we saw the future of agriculture that day. The list goes on, but those investments won't mean as much if there's not land to farm. That's why the Farmland Preservation Program is a critical piece of the governor's strategy to work with you and the agricultural community to slow farmland loss. We appreciate stakeholders like Farm Credit America, Farm Bureau, County Mayors Association, County Services, and the Tennessee Municipal League working with us on this. And additionally, the governor's recommended additional support to local governments to help with local planning and expanded landowner education. So all of these pieces work together to support, preserve, and expand our agricultural economy. And we appreciate your support.
Mr. Holt?
Well, good afternoon, friends. Andy Holt with the Tennessee Department of Agriculture Deputy Commissioner. And speaking of friends, actually, Mr. John Avery Emerson and I have been longstanding friends. I actually went to elementary school and all the way through high school with one of his children, who's now a very successful attorney. Today, the purpose for me being here today is just to talk to you about this legislation in terms of as something that you've heard several times throughout this committee and in the full committee over the last several weeks is by having tools in the toolbox. Right now, what we recognize is that agriculture and forestry across the state of Tennessee is not necessarily under attack, but it is certainly being impacted by the growth that is taking place all across our state and pretty much in every corner of our state. You've heard about these tools and toolboxes as it relates to other pieces of legislation. And I would say today that what is being brought forth is a tool that most certainly will not be the answer for every farm in the state, but it certainly can be an answer for some producers and some farms across the state. In the legislation, it speaks to under 1A, it says it's the intent of the General Assembly to preserve farmland and forest land in the state without limiting the ability of farmers and forest landowners to use their property for agricultural pursuits. And I think that is a goal that pretty much everybody in the General Assembly can agree with. One of the things that I want to emphasize is it's a voluntary program. This is not anything that's going to be forced upon anyone. It's simply an option that would be made available, an option that currently is also available right now, but is not currently available to be in any way incentivized. This would simply be an incentive to allow for these farms to be preserved. And this is something that, again, a a portion of the agriculture and forest landowning community will probably look to as a way of preserving their land. So with that, if there are any questions, be happy to take any. And again, it's good to be back with you and to see each one of you.
Representative Vital, you're first on this.
Thank you, Mr. Chairman, and thank you all for being here. I never thought this issue would be controversial because it is voluntary. Personally, I have a conservation easement, 3 of them on various pieces of property over the years that I have attempted to preserve and to create a legacy of heritage for them, whether they have historical application or agricultural application. I've been involved with conservation easements with many, many individuals, starting out in 2006 with the Land Trust for Tennessee. We have preserved 4,700 acres with voluntary conservation easements in Hamilton County. We've now gone to 137,000 acres in Tennessee in 77 counties out of 95. Those are voluntary conservation easements without incentives. But there are many more people who would like to set the tone of their ultimate property choice of their property, called protection or keeping it agricultural, but need some incentive or help. They couldn't do it. And I think this is what it does. And I think it's a great step for Tennessee moving forward. We always try to be first, but we would be 31st in this case since there's 30 states ahead of us. But I support this and I appreciate all of you being here. There are concerns for sure, but I think it helps us have another tool in the toolbox. So thank you.
Did you have a question you want to ask or just a statement to make there?
Do you have any indication of the level of support for this across the state from farmers since you're involved with the Department of Agriculture?
You're recognized.
I don't have a specific number of farms or farmers that have come forward and have requested this. I think there are several folks who are waiting to see what happens with this legislation before this committee and the other steps that are necessary before its passage. And then upon passage, if it does see fit by the General Assembly to reach that point, obviously the department will need to promulgate rules. That will be hopefully a very robust process of listening to multiple stakeholders to see what would serve the producers of Tennessee the best.
You're recognized for the follow-up.
And just as a follow-up, does the state agriculture department or accredited land trusts serve as the vehicle as you envision this program for the state of Tennessee?
You're recognized.
Thank you, Chairman. The program this year incentivizes participation with nonprofits that are already in the space. So the Department of Agriculture would not be the easement holder.
So you envision accredited land trusts or accredited organizations in state working with you to do that?
Yes, sir.
Thank you.
Next on our list is Representative Shaw.
Thank you, Mr. Chairman. I just briefly want to thank you all. Thank you all for being here, everybody for being here. And thank you, Mr. Commissioner, for taking the lead on this. I really think that this could actually lead into a lot of generational wealth as well as keep our farmers preserved. So thank you for this. I think it's a good start. You know, I do feel that we might need to do tweaking as we go along, maybe a few years down the road, but I do think this is an awesome opportunity for our farmers. And I know how vital they are to our economy, keeping food on the table. So thank you so much.
Representative, do you have a question, Representative Shaw?
No,
Okay. Representative Fritz.
Thank you, Mr. Chairman. The question may be for legal on this since I'm going to ask about the definition of something, but the way I understand an easement has a beneficiary. In this case, the beneficiary of the easement would be the state of Tennessee. And it would be voluntarily gone into place. But I guess my question for legal, my first question is, do we currently have the opportunity for deed restrictions? I, as a property owner in my acreage, can I deed restrict that property to prevent or change its use in the future?
They are looking into that right now.
Okay.
Do you have a question for them, for the witnesses?
I will follow up with that. One of the concerns, thank you, Mr. Chairman. One of the concerns I've heard about, and I understand we're trying to get a tool in the toolbox, and I'm sympathetic to that, but I'm afraid this may be more than a tool. It may be a handcuff for future generations. And I think our founders and our framers of this nation would have been highly suspect of giving the government control over their property. I think the voices from their graves from 249 years ago are screaming out, don't do this. Doesn't matter if 30 other states have done it. And so I'm cautious about that. I see all the moves within the United Nations to end property ownership in the world. And those things greatly concern me. So I'll just offer those comments and hear anything that you all have to say. Thank you.
You're recognized.
Thank you, Chairman. Only that we sought to make clear that the landowner never loses any control over their property, and that the nonprofit that they contract and partner with is also restricted in its control of the property. But to put a very fine point on it, the voluntary program that the landowner enters into, that farmer does not lose control of his or her property.
Say if one of these NGOs were to be centered in Pennsylvania, they were to hold the rights or the contract on this conservation easement, and there were to be a dispute between the farmer and the landowner. Where would that dispute be settled? And to Mr. Emerson's question earlier about, is there a chance that the conservation easement holder could actually bleed that farmer dry as far as with his finances and eventually take over the property? You recognize?
Thank you, Chairman. One of the things that I'll lay out for the committee is that we give the commissioner the authority to promulgate rules around which nonprofits would be qualified easement holders. And so we fully expect the team of the Department of Agriculture to fully vet the land trust or other nonprofits that would qualify for this program, because we're sensitive that we don't want to invite bad actors into the state. But to the mayor's point and to your question, these are contracts that are negotiated between the farmer, the landowner, forester, and the nonprofit. And as such, contracts, any contract dispute would have to be raised in state court, not in federal court. There's not a federal right that is asserted in this program. So any dispute would be taken up in state court by the nature of how the law works in Tennessee.
Representative Martin.
My question, Mr. Chairman, is for legal, but I'll let you decide that.
I think they're working right now. They may not be all ears on deck.
Okay. My question is this, Mr. Chairman, is if a farmer makes this agreement with this land trust company or whoever it is, and when the farmer passes away, is this go to the next generation and the next and the next and the next, or does it end where if I had a great-great-great-grandfather who put this in that land, would I have the opportunity? When does this end is my question.
Mr. Lewis.
Thank you. Yes, this is a permanent easement program that the easement attaches to the real estate. It's recorded in the Register of Deeds office, and it runs with the land from owner to owner. There are no restrictions on the sale of the property. So the property can be sold, can be inherited, can be in any other way divested by the farmer, but the easement does run from one owner to the next. In the same way that other easements that utility companies may have, or if you've got a neighbor that's landlocked and they've got a driveway easement across your property, those sorts of easements run with the land. This is not dissimilar from those easements that currently exist.
Our tag team champions here in legal are going to answer this question for us. You're recognized.
Thank you, Mr. Chairman. Doug Garrett with legal. Alex is right. I'm sorry. But yeah, they do run with the land in the form of equitable servitudes and restricted covenants. I don't know whether there's a limitation on how long, whether the rule against perpetuities comes into play with that. I don't think so, but they do run with the land.
Representative Martin, you're
Ju-
recognized.
Just as a follow-up, that's a good explanation. So if somebody sells the farm, or not then sell the farm, but they put the easement on it, that easement's got to be there no matter how many times that farm is sold. But let's say the state comes by or the county comes by later on, they need to build a road through there. Well, there's already the one easement. How does that get undone if something like that has to take place?
That's yours.
Well, I appreciate that your attorney said I was right on the last one. Hopefully, I'll get this one right too. My understanding is, and I've looked at a couple of the contracts that turn into the easements, and there are clauses that allow when eminent domain comes into play, when there is that situation, that the land can be, the easement can be lifted insofar as necessary to accomplish that eminent domain purpose. So if a piece needs to be taken, it can be taken for those limited purposes.
You're recognized.
And would that be promulgated through the rules? That type of scenario that you say you've read in other contracts, but I'm talking about this language for this law.
Thank you, Chairman. I think one of the part of the way that I'll answer that is in working with the department, because there are so many other states that have programs in this space. We will do our best to look at whether that sort of piece is necessary in the rule promulgation process, or if we just need to clarify that has to be in the contract. So it's not something that I have a definitive answer on, but we certainly have other states that we can look to for real world application of if that's necessary.
Representative Todd.
A lot of my questions have already been answered, especially with easements. I was thinking the same thing, that it's like a utility easement that runs permanently with the property, no matter what happens to it. And certainly the eminent domain issue came up. So I think that's all I had. So thank you for that.
Representative Fritz.
Thank you, Mr. Chairman. I think legal may have the answer on the question I asked about, could I currently deed restrict my own property for a certain use?
You're recognized.
Thank you, Chairman. Doug Garrett with Legal Services. Yes, I think the answer to that is yes. As was stated here, you can impose or not add those to those that would run with the land, equitable servitudes and that sort of thing. So, yes.
Thank you. And that illuminates my concern. I too am concerned about our lost farmland. I really am. But when we're going to make the property owner subservient for a long period of time, and subsequent property owners subservient to either some nonprofit or through the state of Tennessee, I've got to say again, I think our founders are rolling over in their grave about that, colleagues. And if it is about, indeed, just about choice, I can place that easement on my property today, and it doesn't cost the state, the taxpayers of Tennessee, $25 million to do it. So thank you. I appreciate it.
Thank you for that. Now, I got a couple of questions I want to ask. Explain to me how the program will work. You know, we've got the parameters here, but the department's going to promulgate rules. How are people going to apply? How's the money going to be administered? What's going to be per acre? Is it going to be based upon population, based upon demand? What's the parameters? Both of y'all, everybody.
Yeah, thank you, Chairman. And yes, you've identified the big markers for implementation passage, first of all, which we don't take for granted, and then rulemaking that the department will set up the process. I was thinking through this question because we've had this conversation recently, and I came up something that you all have already done came to mind. You all passed the volunteer firefighter equipment training grant program a number of years ago, and that created a statutory scheme that's quite short, that delegated to the Department of Commerce and Insurance to develop a plan by rule, and then a competitive application and grant process. This will be very much similar to that program, where individuals will come to the department and apply to participate in the program. We know that there will be robust, as Deputy Commissioner Holt said, interest from the stakeholders to make sure that we are using this money as efficiently and effectively as we can to stretch to really make a difference to actually help stem the tide on farmland loss. We want this money to be used as best we can. I think to your question about how much and spread out, Chairman, the best way to answer that is that there are a couple tracks that depend on the appraisal that the property will, in order to participate, you have to have an appraisal. And so that will tell us what the value of the land at its highest and best use, the market value versus its current use, the agricultural use. And so we'll be able to see how much of the difference in those two, and then we'll use that to value how much the state will grant as an incentive. We know inherently the land in West Tennessee and your part of the state is very different than over in Representative Alexander's part of the state. And we know that land is valued differently and it's used differently. And so we want to create a program that reflects that diversity in our agricultural and farmland uses.
Director Holt, or Commissioner Holt, excuse me.
Yes, and thank you again, Chairman, for the question. So, different things that have come to mind for us kind of in the precursory meetings and talks about this legislation, if it were to pass, would be what types of land would be prioritized? Where would that land be prioritized? How would that value of that land be awarded? And so there are a number of questions that have yet to be answered. And that's, I think, where the promulgation of these rules and stakeholders' investment and time and thought to be evaluated would be a part of this process. One of the ideas that has been brought forward is that, and again, as Mr. Lewis has noted, in an effort to be as prudent with these funds as possible, would there be an assignment of a specific value per acre? Would that be a bid process? And there's several questions that are yet to be answered, but this would be done again in this promulgation process with several stakeholders involved to help us craft the best plan forward.
I've said this several times, and I'll probably say it 5 or 6 more times before we get out of session. Last year, the agri community lost about $785 million as far as gross receipts from what it was a year before that. The best way to save farmland is for farmers to be profitable, so they don't have to sell their farms to residential or construction needs. So anything we can do to add more markets, to develop more markets, to create new markets is a good thing. And I know you used to work in that field, but there's lots of concerns. I mean, I understand the premise behind it and the effort behind it, and I understand the governor wants to see. We do have the Department of Economic and Community Development that it's constantly working to bring new projects to the state, and when those new projects come to the state, they put a burden on the communities for housing, for more land. And we've got to get the right balance. So I know that's got to come into play. Mr. Emerson brought up some points though about the fear of what it could do to locals and how it would put a burden on municipalities and counties. Would you give us just a little more insight of what you actually had on that, Mr. Emerson?
I'd be glad to. For example, I'm mayor of Alamo, and we have some parcels that were annexed by the town of Alamo with the petition by the landowners a number of years ago. Those parcels have always been used agricultural, and they still are today. The landowner asked, because this property abuts Highway 412, and they asked that it be zoned commercial, which we accommodated them, recognizing that the very short distance from our existing development to 412, this makes sense. In addition, we have sewer and water there. Now, if they go and put that in a conservation easement program and decide to just take the money up front and we'll just keep using it as pasture, you've essentially nullified our zoning and planning process. And in discussing this with Tennessee Municipal League, which I am not authorized to speak for on anything, because we've butted heads on a number of things in the past, but there are probably dozens, scores, there may be 100 or two of communities and certainly counties that have currently used agricultural land that's zoned for commercial or industrial purposes.
Representative Alexander.
I just want to make sure I understand something, Alex. This is truly permissible. There's nothing that would force anyone to do this, correct?
You're recognized.
Yes, ma'am.
Okay.
Well, seeing no other questions, that's the end of our list. Thank y'all so much. We have Kevin Hensley from Tennessee Farm Bureau as you're making your way up here. Now, I was supposed to do this early on in the committee, but Miss Emma Oosley is celebrating a birthday today. So you want to stand up and wave to everybody and tell us how old you are? Now, we give TDEC a hard time in this committee, but we love everybody that works over there, and we do want to celebrate her birthday with her. So whenever she leaves, y'all make sure to tell her happy birthday. Kevin Hensley, you are recognized.
Yes, sir. Thank you. Thank you, members of the committee. I appreciate all of y'all. We worked hard this year on lots of different things, and we've worked hard on this issue for a couple of years now. And when people have asked, why does Farm Bureau support this so much? Because it works. We live in a great country that the states are the laboratories of democracy, and we get the opportunity to learn lessons from other states about what works really well and what doesn't work really well. And as an organization, our farmers across the state, that's been asked how popular that is this program could be. The number one issue for several years has been farmland loss, and we stepped back and said, okay, what works in other states? And these programs are wildly successful. In fact, usually the biggest complaint that we have is that they're so successful, the state runs out of funds to support everybody that it wants to support. And we're a conservative state fiscally, and not everybody's going to be able to participate that wants to participate. But these programs work, and they're wildly successful. And it's not a blue state issue or a red state issue. It's states that are facing the pressures that we're facing similarly in Tennessee. So I won't go down that list, but kind of the eastern half of the country has these styles of programs, and they work very well. And a couple things I want to address. I agree with Chairman Grills. Farm profitability is a huge concern right now. There's so much that goes into that. But I have had farmers tell me my number one profitability issue right now is I don't have land to farm. I physically don't have a place that I can go to farm because everybody's sold out around me. They can't expand their operations. They're young. They're limited in their financial ability to get a loan, and there's not the land. They can't compete with what's going on. And this is it's not going to solve every issue, but it works really well. The programs you can do a lot of things today. People that put their land in land trusts today, generally speaking, have wealth off the farm that they get the federal tax benefits to do this. The people that participate in the state programs are ones that don't have that wealth off the farm to participate. And that's what the states step in. That's why they're so successful in other states, because the states step in and help them do this. Deed restrictions are an option, but there's not that financial incentive in deed restrictions. And there's also not the ability for somebody to have oversight. And I think to kind of wrap this all up, we're creating an option for farmers that if they choose, and they get the thing about this bill this year is that they get to choose who they want to work with. That's the great thing about this proposal this year is the landowner says, hey, look, I think this is the right thing for my family. I've made promises to generations before me, and I want to do this. We have a reason that we want to save this farm. It's more important than just than things that we can describe. We want to save this farm, and this is just a opportunity for folks to do this. I get pretty passionate about this because it's a concept that we know works. It helps farmers of all sizes. I've run out of time, but I appreciate y'all, and I would appreciate your support.
We have anybody like to ask a question? Representative Fritz, you're recognized. Fritz.
Thank you, Mr. Chairman. Thank you for coming today. I appreciate it. You know, you and I are on opposite sides of this. I agree with you on the preservation and the volunteer basis. I get that. But the big difference in this is we're going to use $25 million of Tennessee taxpayer money to incentivize those people to do something they could do for free otherwise, or for what the attorney charges them to write up the deed restrictions.
You recognize?
I don't know that I have a question to answer there other than to say that the opportunities that to do this, there's a cost involved to it. There is absolutely a cost to do this. I've sat through the process of looking at what it would look for my family to do this type of thing. And you're looking at $30,000 to $50,000 up front by the time you do all the legal fees, by the time you get all the appraisals, by the time you get the survey done. And that's just the cost to do it, let alone the perceived loss in value from the appraisal. And this is just especially with it being a permanent option, it's a wise use of taxpayer dollars. I think it's a wise use of taxpayer dollars to say that the people of Tennessee are going to have local food for generations to come. And I think that's something that I hope we can all support, that there's an intrinsic value beyond just the economic value that farming brings. But there's a value to being able to look out in your community and seeing farmland in your community. There's a value to be able to go into the farmer's market in your town and know you have a farmer that you can talk to and that you can buy food from. And again, not going to solve every problem in the world, but it is a great option for the state of Tennessee.
Any other question? Seeing none. Thank you, Kevin. What do you think the up and operational time will be for this? Just if we pass it and it goes into effect July.
We'd have to go through the GovOps process. I mean, we're looking at some time to get this up and going.
It takes at least a year and a half, probably.
I'm happy to say what 6 to 9 months is what legal just said. I mean, it's going to take time, but anyway, we would hope to be involved in that process.
Thank you so much, Mr. Hensley. Appreciate it. Any other questions? Seeing none, we'll go back into session. So without objection, we're going back into session. First course on the bill. Representative Jones, we'll recognize you first on the bill.
Thank you, Mr. Chair. This is an issue that I've through better information, I had a change of mind on. I voted against this bill last year. We know that this bill died in the Senate last year. We've got a lot of emails about this legislation, and I'm always transparent about the emails we get, and most of them were against it from my conservative friends. So I was going to let the Republicans fight this one out, but I want to speak on this because, I mean, you all are fighting each other on this, so I was going to let you. But I talked to young farmers, and this bill will help young farmers be able to remove some of the barriers of entry and to be able to preserve farmland. And so we had a convening in my office with 40 young farmers from across the state, and this was something that they said that they support. And that's why, for my constituents, and just transparently why I'm changing my vote on this is because these young farmers said they support this and it will help them. And so I want to vote in things that will do. I'm always skeptical of the governor and things his administration brings, but the Department of Ag is one of the agencies that I trust, and I think they have the best commissioner of all the commissioners here. So thank you all for being good partners in this work. And so that's why I'm switching my vote, and I just wanted to be clear about that. Thank you.
Representative Cochran, you are recognized.
Thank you, Chairman. If there are no other questions, I will just, I guess, give a final comment on it. Just we've talked about. I think that the important thing to emphasize is it is a voluntary program. It is one additional tool that we could implement to preserve our farmland. And to Chairman Grills's point earlier, I think this should absolutely be the first step. I think this is a small step, and I do think that ultimate answer is that we look at ways to incentivize profitability for our farmers and ensuring that we're being innovative and enabling that innovation for our farmers in the same way that we do for industry. Every year, we fund ECD to the tune of tens of millions of dollars, and that is to incentivize economic activity. That's what this is doing. And so as far as using government funds to incentivize economic activity, we do it every year, and we vote on that budget every single year. We do it for industries and factories. This is one small step to do it for our farmers, and I hope it's just the first step. Thank you.
Thank you for that. Seeing no other questions, we'll be voting on sending House Bill 1325 as amended to full committee. All those in favor vote aye when the board opens. All those opposed vote no. Mr. Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 1 nay.
House Bill 1325 goes on to full.
Thank you,
See you
Chairman
next
and
week. Chairman Powers, you still awake over there? Item number 20 on our calendar, House Bill 771. We have a motion and a second. Do we have an amendment?
Yes, there is an amendment. It's amendment number 6417.
6417, that's what I have. Does it rewrite the bill?
Yes. Yes, it does.
Okay, you'd like to put the amendment on the bill then?
Please.
All right. Can I get a motion on the amendment? We have a motion on the amendment and a second on the amendment. All those in favor of Amendment 6417, say aye. Any opposed? Say no. The ayes have it. The amendment has been put on the bill.
Thank you.
And you're recognized on the bill as amended.
And while I was asleep, I did have a dream that I had a unanimous positive vote on this bill. So I hope y'all can.
He was
make that come
dreaming.
true. Just keep dreaming. But I know Representative Renault mentioned this a while ago, and I know you probably all don't care, but it did pass 9-0 in Senate Ag. So I am proud of that. It's not dead or anything yet. But anyway, what it did, I put an amendment on this bill, and it rewrote the bill, but it was primarily the same bill, other than just made a different. We addressed the concern that y'all had last time when I brought it. But I will just briefly go over the regular bill, but it requires boats that are not numbered in the state of Tennessee that have a valid number from another state, that it requires them to pay a $72 registration fee if it's an out-of-state boater, and that purchase a permit from TWRA. Because of the increased traffic on our lakes and everything, the erosion and the damage to all the personal docks and property, we do need more TWRA personnel on the lakes to help patrol it and enforce the laws and make our lakes safer for everyone. I know I've dealt with that before. I actually sold my boat because the lakes were too crowded in my area. I represent 3 counties that surround Norris Lake, and it's becoming more and more dangerous every day. And it's simply not because we don't have laws in place. I passed a law or carried a bill a couple of years ago that required boats to stay 200 feet away from a personal dock or any property, but there's nobody there to enforce it. If there's nobody there to enforce it, the laws are really irrelevant. So that's what we're trying to address. And the concerns of the committee last time I came forward with this was that fishing tournaments. So that's what the amendment did, that we added onto it. It carved out for individuals who have purchased a fishing or hunting license, because you have to have one to fish in any of the lakes in Tennessee anyway, as they have a fishing or hunting license for a tournament, or if they hunt from their boat. I don't know who hunts from a boat, but they put that in there. I've never seen anybody do it. Do they really? Well, okay. But that also, if they have a hunting or fishing license in the state of Tennessee, then they are exempt from this bill too. So it's just really about out-of-state boaters. Most of them are just recreational boaters. And it was brought to me by the people around my constituents around those 3 counties, Norris Lake. Not a day goes by in the summer that I do not get a complaint because of damage to their dock, erosion on their property. And I really wanted to bring this bill forward to help put more TWRA people on our lakes to help make them safer. A couple of years ago, we had a 12-year-old that got killed in our district. It was an intoxicated driver from an out-of-state boat. And we just don't have the resources, TWRA, to adequately patrol the lakes in our state. And this bill will help fund those efforts by TWRA and help keep our interstate, not interstate waterways safe. And with that, Mr. Chairman, I renew my motion. Be glad to take any questions.
First on the list, I have Chairman Todd.
Thank you, Mr. Chairman. And I do appreciate your effort, and I appreciate your concerns and what your goals are in this. I have some concerns that I've expressed with you. One being tourism. You know, the folks that you refer to that are coming from out of state are no different than me when I go to another state with my boat. I'm paying for fuel usually there, some kind of lodging, eating out, buying lures, you name it. And some of that money ends up depending on what state I'm in, directly or indirectly into the coffers of the agencies that regulate the very things you're talking about. And I think the same goes for our state as well. And I'm very concerned about damaging our tourism in this state, folks that want to come here and enjoy our resources and spend their money. We welcome them every day to spend their money in our state and then leave. So we usually don't, that doesn't cost us that much when they're here.
That's right.
So that's one of my bigger concerns. And this committee earlier this year heard testimony from the wildlife agency themselves that they employ, I believe it was about 750 folks in the agency. We have 95 counties. Not every county has a lake in it that they would regulate. So when you think about that number of personnel and the problems you're talking about, I'm sure they're probably very site specific.
Sure.
I believe they have the resources to do this. I think it's just a matter of let's put the priority there. So I'm with you on that we need to make sure that if there's damage being done, if there are laws being violated, safety issues for sure, then they're tasked with that already, and we need to just encourage them to do that. To your question about hunting from a boat, the previous sponsor to you mentioned some green-headed acorn eaters, and the folks do shoot ducks from boats, not moving. That would be illegal. And some of us shoot fish from a boat. So there's that.
Yeah.
You're recognized.
Thank you. And back in the old days, they used to dynamite from a boat, I think, and kill fish. I don't think they do that anymore. I think it's against the law. Probably was then, but that did happen. But yeah, I understand that. I just wasn't familiar with that particular type of hunting. But this really, when it comes down to it, it's 20 cents a day is what it would cost them, $72 a year. And I guess my concern is more toward our residents. We want tourism and our, we really promote it in our area, and we get a lot of, they'll pay $1,200-$1,500 a night to rent a house there around the lake. The boats that they bring in are anywhere from $50,000 to $200,000. A lot of them are weight boats, and you know what they cost. So $72 a year, I don't think will deter any type of tourism in our area. And it will help pay, what we have to pay. We have to register a boat and pay to help support that lake too. And I think it will just help pay that. And everybody I've talked to, my constituents, I mean, they're all for this bill. They think that, if we have to pay a fee, that they need to pay a fee too, and to help preserve our lake and help patrol it and help put more people on the lake. North Lake, I think, is the largest lake on the whole TVA system and the oldest. And I can go all day, and our TWRA people do a great job, but I can go all day on a boat and never see a TWRA agent out there just because they tell me that there's a lack of personnel. That's why I brought this forward.
If you were dynamiting, you would consider that a success.
I would say a lot. Yeah, that's
for
true.
follow up. Just one, and the $72 was another concern I had, because I think that if I understand correctly from the agency, that is a proposed fee for a 40-foot boat.
Yeah.
And I know probably the majority of the boats that we're going to see are much shorter than that. And so it's kind of disproportionate in my view as well. But just the principle of it, I'm really concerned about the damage to tourism.
You recognize.
And I think what they were trying to do, and I talked to you about this before, there were some fees that were even more than that. And I think they were trying to come up with an average, because some of them are a lot less than that too. So I certainly understand that. It's just, I just really feel passionate about it, because I just see so many things happen on the lake and so much traffic, and we just really seeing a lot of personal damage. I got an email just the other day about all the damage to the dock, and that 200 feet that I came up with a few years ago is not being regulated. It's not being enforced, rather. And a lot of people are having a lot of damage, and there's nothing really to do. They've been told to get the numbers off a boat when it comes by if it does damage, but you can't see one of those boats when they come by. You can't get the numbers off of it unless you're out there with a telescope or something. But there's no way to really, unless you got people out there, we got boots on the ground, there's no way to really regulate that.
Representative Vital. I'm sorry, Representative Martin.
Question on the bill.
Question being called on the bill. Any objections? Seeing none, we'll be voting on sending House Bill 771 on a full committee as amended. All those in favor vote aye when the board opens. All those opposed vote no. Mr. Clerk, take the vote.
Mr. Chairman, you have 3 ayes, 6 nays.
Sorry, Chairman Powers, the bill fails.
Thank you, Mr. Chairman. Committee.
Item number 21. Chairman Bricken. House Bill 1122.
Some body parts did go to sleep. Jeez.
Bill that we adopted earlier this year on 3-5.
Yes.
We have a motion and a second on the bill. You are properly before the committee and are recognized.
All right. Thank you, Mr. Chairman and members of the committee. This is the legislation dealing with biomass in Grundy County. And the legislation, all it does is authorizes the county to do the work that's in regulating the biomass that comes to their county in the same manner that TDEC should be regulating it. So they're going to take it upon their shoulders to test it and be sure it's properly spread. So it's specific for Grundy County only. And so they're going to kind of partner, if you may, with TDEC. I mean, TDEC can still do their thing, but this allows Grundy County to do their thing and properly regulate the biomass that comes to their county. It is a serious problem. We talked about it 3 weeks ago here. If it works, if they take it on, then I think they will. They'll get the results of that they want, and certainly the biomass problem in Grundy County hopefully will subside. I have my friend, the mayor of Grundy County here, and he certainly would like to talk if it's a good time to allow him.
Without objection, we'll be going out of session. Or unless you'd like to stand at the podium.
Okay, thank you.
We're out of session.
Thank
you
you.
have 3 minutes.
Thank you, Mr. Chairman, committee members. I'll make be brief. I know I'm tired as you are. I was here all day with Leadership Grundy. Went back to our.
State your name, please.
Michael Brady, Grundy County Mayor.
You're right.
Was here all day yesterday with our leadership youth. Went back for a county commission meeting and was back here at 1 o'clock last night because I feel so passionate about this bill. Also, our high school was tuned in at 3 o'clock. I'm sure they're going home now, but I believe they'll be viewing this tomorrow. One thing that I was saying, tourism. Tourism, I appreciate that comment. You're in the county seat, you're at a coffee shop and you smell biomass. Does that make you want to stay there? Does it make you want to go visit the creeks and streams? It wasn't me. One thing is Grundy County has a sewer system. We're the only 2 counties in the state that has a county-run sewer system. The state regulates that and makes us keep records and test on that. So we can be trusted with our own sewer, but we cannot be trusted with sewer coming into our county to regulate that. So that's a question too. If we can regulate our own sewer and everything and have it tested and it be safe to do application that we do, can we not regulate what's coming in from other areas? Also, Grundy County, they talk about permitting and other things. Is this legal? It's done every day. There was a bill passed this morning in the Senate that gave special permission to another county. Also, the state has a program now for biosolids, or not biosolids, but permitting that you can do your own perk test within a county if you satisfy certain regulations. Again, there's over 2,900 PFAS that are spread, 9 metals that they test for. If any of those metals get through, they get on the farmer, his career is over on that farm. We passed a resolution in 23. We wrote a letter in 24. We wrote another letter in 25. Still, I can provide you with pictures and letters and everything where this is being spread on our roadways and other things. So what is wrong with having another layer of protection, because another year of this being spread is another year that we have 3 schools that this is being spread within a half a mile. It's been spread within less than a mile of the county seat. I've got the documentation where there's concerns with students over that. This has made its way into farms and into ponds. It's made it into waterways. So I'm asking you to please allow us to just regulate this. We're not going to take the authority away from nobody. We're not where we want to follow the EPA guidelines, the guidelines that TDEC has. Work with TDEC and just monitor this in Grundy County so I can protect the people that I love.
Thank you, Mayor. Do we have any questions? Representative Shaw.
Thank you, Mr. Chairman. Thank you for being here. I know we talked earlier. So are you saying that TDEC does not respond to the request?
If you look at that picture that I showed you where it was
Yes,
spread
I
on the
saw that.
roadways, I called TDEC. They went out and they said there was a violation, but there was no repercussions. No repercussions, and that happened at other places. We've been at this for a long time.
Representative Shaw.
Thank you. But I think my question I'm asking you, did they clean it up?
I think Rain cleaned it up. They didn't go out there and clean it up themselves.
Representative Shaw, we'll have TDEC, after the witnesses, we'll have TDEC come up and be able to
Okay.
answer questions.
Thank you. Thank you. I'll ask that. Yeah.
Representative Jones.
Thank you, Mayor Brady, for coming back. And I wish every mayor in all 95 counties fought as hard for their constituents as you do. So thank you for coming back. I was taking some notes just from some new things that came up in this testimony. You're talking about how your county can regulate your own sewer, but you cannot regulate what's coming from other areas. And so there's already a model. And so can you kind of talk a little bit more about that, just about how this is similar to that? Like this would be very similar to what you all are already doing in terms of regulating your sewer, but now this is about regulating the biomass coming from outside of your community, and that's adversely impacting the students and families and community members in Grundy County.
Yes, we have 2 sewer systems. I'm sorry.
No, you're fine.
We have 2 sewer systems in the county. One of them is a discharge permit. The other one is a land application. Those require different levels of training and testing. The one that is a discharge permit, we test that pretty much weekly. Whenever you have a land application, we test that on a shorter basis. But we have to test it for everything from ammonias and other things before we can apply that or discharge that. But what is coming in to Grundy County, there's no testing for PFAS and only being tested for 9 metals. So I tell you another instance real quick. Had a gentleman that couldn't get a perk test on his property a half a mile where they were spreading this 8 tons an acre, but he couldn't get a perk test because he had pushed a little bit of dirt away.
Representative Jones.
Thank you. And I know that last time we had Farm Bureau against this, but is it true that your local Farm Bureau supports this legislation and the folks locally?
You're recognized.
Our Farm Bureau president, our local Farm Bureau president is Steve Ahern, AA Farms. He tried this on his farm. It rained. It got into his brother's pond. It killed all of his fish. They did nothing. They paid no attention to the flags. And he told me right after this meeting, he said that it will never be on his farm again.
Thank you so much.
Thank you so much for being here. We have no other questions, and thank you so much, Mayor, for making the long trip back up last night. Representative from Farm Bureau, Mr. Kevin Hensley, is on the list as well. And while he's talking, those representatives from TDEC, will y'all make y'all's way and sit at the chairs?
I'll
save time.
I'll be brief. We talked about this last time. I'll just
state your name.
Sorry, Kevin Hensley, Tennessee Farm Bureau. I'm sorry. I testified last time. I think to kind of just put it at a point on what this bill does. This would be the first time that this committee puts more regulation on agriculture through a bill. If you support this bill, just read section 1. B2 is the first place I can ever remember that this committee's actively supported putting more regulation on agriculture. And while throughout the day today, I've had several folks back in that area have been texting me saying, what's going on with this? Because they use this product. They rely on this product. It helps in their farm profitability, as we've already talked about, because fertilizer is so expensive. This is a good alternative. I feel for the problems that have happened in Grundy County. And I think that there's a regulatory approach that we need to take. And I would just encourage this committee to really make sure we're thinking about what we're doing here by granting this. This will be the first time that I could find in code that this type of new regulation would be added, especially for just a single county like this. So thank you.
Representative Jones.
So, thank you. What you said doesn't make sense to me, because what I see this bill as is about local control. And we have voted for that many times on this committee and in this body, that local counties, we believe in small government, local government. That's what this bill is about. And so my concern is that what we're hearing this bill is trying to do is just trying to allow another tool where if TDEC does not respond, then the local government can test these products, these biomass solids, and see if they're harmful to their people. I think that sounds like it would make sense. It doesn't seem like a regulation. It just seems like a common sense safety precaution that local people who live in that community should have a say in what's going to happen to their health and their children's health. Can you explain why you think this is a regulation on agriculture, not an issue of local control? Even your own Farm Bureau president in that county has concerns about this. Have you spoken to him?
You're recognized.
I know Mr. Ahern very well. I've worked with him my entire career at Farm Bureau. I've known him for 12 years now. I can't speak to the certain specific circumstances that he had at his farm. We have not talked about that, but I do know there are other farmers in Grundy County that use this. There's other farmers in the region that use it. But specifically to your question about, is this regulation, Section 1B1 is the current law. So when you look at the bill, Section 1B1 is the current law. Section 1B2 is the new addition that we're adding here. And it is, as it pertains to the prohibition or regulation of land application of biosolids, which is regulated by such county's body. And not only is it regulation, what this will happen, this will be a prohibition. This will be taking away from people's access to this affordable fertilizer. I don't want to diminish the problems that they've had in Grundy County. The examples of it being on the road is an absolute violation of their permit, and there should be enforcement of that. But this is a tool that farmers use. There is a smell that is associated with it, but that's just like anything on the farm. Farms have smells, they have funny sights. Things happen on the farm that other folks aren't used to if you're not around the farm. But what this would be a prohibition of people having access to this tool.
Representative Jones. Hold on.
I think we keep minimizing this to just being about a smell. I think that's a part of it, but I think it's also the health implications of what these PFAS chemicals do long term. It's not just a bad smell, but it's bad for people's health. I think that's the concern. And so I think this is about local control. And apparently, you said this gentleman. He's the county president of your organization, and you didn't ask him about this. Only affects one county, where their county stands on this, which shows that we're not listening to local people. I think it would be in the best interest of an organization to reach out to the president in that county and say, where do you stand on this, before coming up here into the General Assembly and speaking into a bill that only impacts one county. I'm from Davidson County. I've only been through Grundy County once, but I come up here every day, and I believe that we should have a say in what happens in our communities. And that's what this is fundamentally about. And I've heard time and time again on this committee that we believe in local control, local government closest to the people is the best solution. That's what this is about. And I'm always skeptical of lobbyists who don't talk to the people who actually live there and are dealing with the issues. And so that's my concern. And so I thank you for coming up here today. I just know that it might be beneficial next time to call the people in that area and ask them how they feel about it, particularly when they're part of your group.
Mr. Hensley.
Yeah, like I said, I've had texts from folks in that region today about concern about what this would do to their ability to access a affordable thing for their farm. And then I share the concerns about PFAS. I think that is something that as a country we're going to have to deal with. And the EPA and TDEC is working on that. in the 2 to 3 minutes we have right here to discuss PFAS is a 2 or 3 day debate and discussion. PFAS is a topic that the EPA is actively working on. TDEC has a working group that they have put together that we are fully supportive on. And if you look at the comments that Tennessee Farm Bureau has submitted to the permitting process that TDEC has, we encourage them to follow every single guideline that comes from the EPA recommendations. And then we also support their effort on their PFAS working group.
Representative Shaw. You're recognized.
Thank you, Mr. Chairman. And I certainly recognize the fact that there's nothing TDEC anybody can do about the product that farmers put on the field, and they use it for fertilizers. I guess what I would ask, is there anything in statute that says, and I don't know, maybe this is a little wild, but if I bought 2 acreage from you, from your farm, to build a home, could there be something in statute that says I would be warned before you use the you use the product on your farm near my house? Is that something could be done? Because I mean, we had some of the same issues back in West Tennessee, and I realize the farmer needs to use the product for growing purposes. I get that, but I guess I'm just wondering, is there something in statute or could be that a person would say, now, if you build a home here, be warned, we use this product, and you might be a time of the year when there's a stink.
Yeah, I'm sorry. Thank you, Mr. Chairman. There's no such statute that I'm aware of, but there are guidelines that when there is application of this product, there are guidelines they have to follow, and I would defer to TDEC about what those are.
Yeah.
If they don't follow those guidelines, they violated their permit. So that's, I guess, would be my response to that, Mr. Representative.
But I take the risk. If I build on the countryside, that's just a risk I take.
You recognize?
I assume so, yes, sir.
Yeah. Okay.
Thank you, Mr. Hensley, for being here. We have no other questions.
Thank you very much.
You've earned your paycheck today. We have 3 people. Well, I am actually a member of Farm Bureau, so technically he is on the payroll for my farm. How about that? I'm sure there's several members up here that are members of Farm Bureau, by the way. TDEC, Allie, you're recognized.
Thank you, Chairman. My name is Allie Williamson. I'm the Director of Legislation for Department of Environment and Conservation. With me today is Stephanie Derman. She's our Deputy General Counsel, and April Grippo. She's our Director for the Division of Water Resources. And I want to introduce them because they're going to break this up a little bit and talk about the legal issues that are presented with this bill, but more importantly, the policy changes that TDEC is planning to do, currently working on to address the issues that are presented today.
April Grippo, Director of Water Resources for TDEC. TDEC recognizes and affirms the legitimate concerns of citizens and local governments, like we just heard from Mayor Brady, regarding land application of biosolids, and we're committed to improving both our permitting and enforcement related to biosolids, not just in Grundy County, but statewide. We're very committed to assisting our friends in Grundy County to resolve the specific issues that they are dealing with. And we feel strongly that the changes that we are working on right now will help to resolve those issues. Our biosolids general permit is currently up for renewal. It expired in the fall, and we received a number of comments on the draft permit, and we are working on a final permit that will reflect those comments, that will have strengthened conditions, including adding a new requirement to test for PFAS. We just received EPA recommendations on PFAS earlier this year. So we're going to incorporate those. We're going to strengthen conditions about the storage of biosolids, and we are going to establish a regular system of inspections and audits to ensure compliance with this new permit. As far as enforcement, we have received a number of complaints regarding biosolids violations. And so far, we've been addressing those through our typical practice, which is sending notices of violation and requesting a corrective action plan to try to get a compliance problem resolved before we go to formal enforcement. We don't typically issue penalties for every single violation we find. But when NOVs don't work, the next step is to move on to enforcement orders. We encourage people in Grundy County and elsewhere, if they see what they believe to be a violation, to file a complaint with both TDEC and EPA. In addition to those complaint investigations, TDEC plans to establish a regular system of inspections and compliance audits during each 5-year permit term. No one's going to argue that we should get rid of sewage treatment plants. They're a great achievement of the Clean Water Act, have contributed substantially to cleaning up our nation's rivers, and biosolids are a product of this sewage treatment. If biosolids are not land applied, they would have to be sent to landfills, and we all know that landfill space is a limited resource.
Ms. Derman, you're recognized.
Stephanie Derman, Deputy General Counsel. TDEC has concerns about the constitutionality of this bill under Article 11, Section 8 of the Tennessee Constitution. This bill affects only Grundy County and would treat that one county differently from the other 94 in Tennessee with respect to an environmental law of mandatory statewide application. This precise type of bill was found to be an invalid class legislation in a 2004 Attorney General opinion, and the number on that is 04-105. That bill, in fact, involved TDEC. It involved the Water Quality Control Act and one county that was going to take over regulation, and that was found constitutionally suspect. Further, the bill appears to conflict with TCA 4311-125A, which prohibits counties with a population of less than 200,000 from regulating the use and application of fertilizers. The Tennessee Department of Agriculture has approved the use of biosolids as fertilizer. Finally, in Tennessee, the U.S. EPA is the primary regulator of biosolids. Any attempt by Grundy County to ban the application of biosolids may face federal constitutional challenges, both in terms of preemption and the Dormant Commerce Clause. TDEC believes the better answer and the legally sound answer is to improve biosolids protections for all Tennesseans. Thank you.
First on my list, I have Chairman Todd, but I'm going to skip him and go to Representative Jones.
Thank you so much, Representative Todd. I'm just trying to see how we got here. So this committee they passed a resolution in 2023, a letter in 2024, another letter in 2025, and it took until now to respond, or how have you addressed their concerns along the way? Because this county seems to have brought this issue up multiple years, and now we're saying, well, let's wait and trust us that we have, quote, changes that we're working on right now is what I heard. And then the solution at the end was a very general solution about statewide, but this is one county that is obviously feels like they have not been heard. One of our poorest counties in our state, a county that has continuously tried to get the attention of TDEC, and I guess they have not heard a response. Can you explain what were some of the barriers to communicating with them, or why there has been this lack of response, it seems like, and what people are feeling there? Can you explain how we got here?
Director.
Yes, April Grippo, Director of Water Resources. I'll take a stab at that. So we did investigate the complaints that we've heard in Grundy County. I believe that Mayor Brady was correct in how he recounted that. In a notice of violation, we typically ask for a corrective action plan. So the permittee will provide to us what their plan is. That's typically our soft way to try to get it enforcement. Our goal is permit compliance. Our goal is not penalties and fines. And so in trying to achieve that goal, I think we also had a little bit of a timing issue. So our 5-year permit just so happened to expire in the fall. We got a great number of comments. And then also in the past 5 years, PFAS and the concerns over that, the science around that have really come to a head. And so we needed that time to hear from many, many constituents, permittees, those farmers that accept this product and apply it on their land. And we've taken all of that into consideration and are currently drafting a new permit, which will be more stringent. And I think will address some of the concerns that we've had here. And then I do admit that I think that we have not done a great job of doing routine inspections due to staffing concerns. We plan on addressing that by sending more staff to that area, and also by hiring a contract inspector to try to address some of those concerns for this new 5-year permit.
The follow-up.
Thanks, Representative Todd.
That's
Madam Cruz. We only get one question, so I'm going to do two questions in one. The first question is the solution that the attorney gave was a better regulation of biomass solids statewide. And then can you talk about what that would look like? And the second part of that question is that have we seen a disproportionate amount of complaints from Grundy County, or have we been seeing, if you can recall, where we're seeing these complaints in what counties in the state, and have most of them come from this county? And so if you can answer those two, and I can repeat them if they're confusing. Thank you.
Sure. April Grippo with Water Resources. Let me take a stab at the first one. You're kind of asking about better regulations. So when we talk about that, I think that we're referring to that we're strengthening our permit. So we believe that our permit will have stronger permit conditions. It will require monitoring for PFAS, which our previous permit did not. And then it will also have a limit to how long a farmer that accepts these biosolids can store it. When it's stored and not integrated into the soil or land applied, there's a little bit of a problem. I think you were talking about odor issues and some other things. So that's our plan to address. We've gotten many, many comments that have asked us to do those two things in particular. So that will strengthen our approach on the regulatory side. To answer your question about complaints, we do see a high concentration of complaints in this area generally because a large biosolids generator is the Chattanooga wastewater treatment plant. So Chattanooga wastewater treatment plant land applies many, many tons of biosolids in several other counties. I believe that Grundy County receives the fourth most biosolids from Chattanooga among the many counties where they have agreements with farmers who accept those biosolids. I looked back and I found about 16 complaints over the last 3 years related to Chattanooga's biosolids program, and it looked like a handful of those. I have 2 or 3 specific in Grundy County, so they are spread. Oh, sorry for the pun, but they are spread across the counties that where Chattanooga sends their biosolids.
Representative Todd, you're recognized.
Thank you, Mr. Chairman. And I have heard from the sponsor for the last couple of years about this problem. He has been very diligent to bring it up. I'm sure he's talked to you guys as well. The mayor has expressed his concerns to Representative Bricken over and over. I'm confident, plus citizens. And I have told him multiple times the department will take care of it. You just let them know they will take care of this. It cannot be on the road. It cannot be in a position to get into waters of the state. That's the law. So this is like really easy. This is basic 101 water pollution. And so I trust that he has, and it sounds like you have heard him and you're working on some new procedures. And I would encourage you very, very strongly to make sure these are dealt with properly in every county, not just Grundy, but every county. I've mentioned before that I've had biosolids spread in my neighborhood, just hundreds of yards down the road from my house before, and it wasn't a problem. That farmer wanted it. That farmer got a benefit on their property for that, and nobody had a problem with it. It was done properly. We didn't have it on the road. We didn't have the problems they've had. So I know it can be done properly. I know, and you guys regulate that. I know very intimately that y'all regulate that. I've been there. So I know you can handle it, but we definitely want to make sure this is done so that we don't have to entertain something like this in the future. So thank you for your diligence to stay with this. Thank you, Mr. Chairman.
Thank you. Representative Shaw, your last one on the list.
Thank you. I too agree with Chairman Todd. I know about the product. Matter of fact, I've had the opportunity to come in contact with it a little bit. So I would encourage you all to be diligent to do you all's part. And I'll say this publicly. I realize if the farmer follows all of the regulations and get it to the field, you can't stop the smell, but you can do your part in making sure that it's regulated till it get there, because it is an awful product. But I would just say publicly, people who buy on Countryside need to start asking questions like that before they buy, because just about everywhere on the countryside you go, people are using it. So, and I appreciate what you all are doing. I appreciate everybody trying to take care of the community, but thank you so much. Appreciate that.
Yeah. Thank you, Representative Shaw. Ms. Williamson, I know we met back in the first part of the month. Okay, I'm sorry. Representative Votto, I'll come to you next. there was some talk about, and there was some talk about the shortcomings of TDEC. But since then, you've had an opportunity to go back, talk to the different people that work in that department. Just give us a 3-week update. Where are we?
Specifically with this program?
Well,
or-
just with the problem they've had down there.
Yes, sir. Yes. Well, and that's what I would definitely lean on Director Grippo and reiterate what she has been saying, where when the general permit expired, we made sure to respond to Grundy County and show up and do a town hall. We heard their concerns. We took it back to the department. We held our own sort of public hearing town hall where we put it out for public comment for our general permit. We wanted to hear those concerns, and it's still out for public comment, and we're hearing feedback on that. And so that's where we're saying we are very committed to listening to their concerns and taking that feedback and putting it into the regulations so that we do better.
Do you feel that TDEC is in a better position today, though, to deal with this and the stuff that's gone on over the past 18 months, 20 or 2 years
Yes,
will
sir.
not be happening going forward?
I feel strongly about that, yes.
Ms. Grippo?
Yes, we're working with Chattanooga on their contract with the haulers to try to alleviate some of the problems with roadways that we're hearing, especially from Mayor Brady in Grundy County.
Thank you, Representative Vital.
Thank you, Mr. Chairman, and thank you, TDEC, for being here to answer these questions. I can understand Grundy County's real concern. I think this is a concern that could affect 95 counties. I know there's been some movement by Chattanooga and other biomass operators, if you call them that, sewage treatment operators, to move from Class B fertilizer to Class A. Will that help us with the disposal? Because the pressure's being put on landfills. So this is a double-edged sword on where we dispose of this product in a healthy way. So could you just address that, please?
Yes. You recognize.
Yes, sir. April Grippo, Director of Water Resources. Moving to exceptional quality or EQ biosolids, as some of the wastewater treatment plants in the state have, would increase. It requires more testing. It requires almost like a no permit required process because the quality of the product is so good. It's almost pathogen free. And so I think removes a lot of the concerns, a lot more monitoring. So a lot of the concerns that we're hearing would be alleviated by more wastewater treatment plants moving to EQ biosolids.
The real challenge is farmers are in a desperate situation to survive. We've addressed this earlier. Cost of fertilizer has gone through the roof. And so the more we can move the biomass to a Class A type fertilizer quality will help them and will help our communities across the state. And we've got to address this in all 95 counties. So I really urge TDEC to get ahead of this and not behind it. Thank you.
Thank you. Thank you, TDEC, for coming in and taking our questions. Without objection, we'll go right back into session. Chairman, I'm sorry, Representative Bricken.
Thank you, Mr. Chairman. And just want to make a couple of closing remarks. First of all, Grundy County has no desire to ban biomass in their county. They just want it properly delivered, spread, and tested. That is their goal. So the farmers and Farm Bureau should be supported. It just adds another layer of what you call it, authority to be certain that the rules that are in place are being executed. And for Representative Vital, one of the ideas for future legislation is to require all wastewater plants to get Class A biomass. Even if we put it over a long period of time, like 5 years, because they can't do it immediately. But we should look at that kind of movement to get this quality product, get this product at an acceptable level. So anyway, I'm at the wish of this committee. Any questions?
Chairman Todd.
Thank you, Mr. Chairman. Again, appreciate what you've done. Appreciate your purpose here. And I think you've got some traction with the department to get this right and to make sure that the folks that are distributing this material are doing it according to permit, and probably going to see that the permits tightened up quite a bit. And plus the enforcement I know is going to be there. But to make sure that it does, I think this bill needs to stay alive. And so I move you, sir, this bill to the first calendar of 2026.
So without objection, we'll move House Bill 1122 to the first calendar of 2026.
Thank you, committee.
Thank you. Now we're at the heel of the calendar. Item number 4, House Bill 896 by Chairman Todd. We have a motion and a second. You are properly before the committee. I do have an amendment.
Yes, Mr. Chairman, it's drafting code 4547.
That's what I have as well. Does the amendment make the bill?
It does.
Can we get a motion and a second on the amendment?
Motion.
We have a motion and a second on the amendment. All those in favor of putting amendment 4547 on the bill, say aye.
Aye.
All those opposed, say no. The ayes have it. Bill has been amended and the bill is properly before the committee. You're recognized.
Thank you, Mr. Chairman. This is the Sound Science and Regulation Act, and it provides that any state agency that proposes or finalizes a regulatory action, such as a regulation, rule, standard, public notice, or health-based guidance level for a substance, a mixture, or a chemical related to drinking water, water pollution control, hazardous substances, or contaminated site remediation, air quality, or solid or hazardous waste handling, must base its decision on the best available science. Further, with respect to regulatory actions pertaining to human health, science must show that the exposure to the substance above the level proposed in the regulatory action is causally linked to manifest bodily harm in humans. The amendment on this just is clarifying, has some clarifying language. It's the only reason we changed it from what had been filed previously, just to make sure that we don't make any mistakes here, that makes it more solid and takes care of some concerns that were expressed. With that, I'll be glad to take any questions.
First on the list, Representative Jones.
Thank you, Representative. Last time this bill came up, before it was rolled, I asked if anybody from the Department of Health, Department of Agriculture, Department of Environment and Conservation, those agencies that would be impacted by this bill, were able to testify, or if they had given their opinion on this bill, since they would be the ones impacted. Has that been addressed, or are they allowed to testify?
I don't see anyone here from the Department of Health. And I don't have anyone on my list. No, I don't have anyone on my list from the Department of Health.
I think they're excluded by the amendment.
Chairman Todd.
And that I've not had any opposition from them to your question. They've all been very compliant with this. There are some exclusions that we've written in to take care of concerns that they had. It ensures that new environmental rules, again, based on best available science. And this is the same approach that EPA uses at the federal level, such as the Federal Safe Drinking Water Act, Clean Water Act, section on hazardous substances, discharge prevention and containment, and for chemical risk evaluations under the Toxic Substances Control Act. It does not tie the hands of regulators, allowing them to continue their work to protect the public and the environment. Looking at the exact sections that I think you're asking about. So the amendment and we put an amendment on 4 TDEC specifically, it allows for regulations based on tests performed on experimental animal species or human and animal cells in the absence of voluntary scientific study on humans. So there's certainly anecdotal information that many tests have, and that's included. They also suggest that scientists, there were some concerns from scientists and Southern Environmental Law Center, and the amendment expands the types of supporting studies. We want to make sure that was broad enough that can be used to justify an environmental rule. Now, in addition to studies published in a refereed journal, that's the quote, regulators may rely on these sources of support as well. Site-specific studies, including area-wide or statewide studies, external peer-reviewed studies contained in a federal government report published for a purpose other than development of the agency's rule, and maximum containment levels, regional screening levels, and vapor intrusion screen levels published by the US EPA. So I hope that answers what you needed.
And follow up.
Thank you. So last time we, again, had this legislation, we received a letter from not just environmental lawyers, but from academics, professors at Vanderbilt Law School, Vanderbilt Department of Science and environmental scientists, plant conservation, professor of earth sciences at the University of Memphis. We received, it was about 20 professors and folks who do research who were afraid that this bill was too broad in scope. This bill has not been passed in any other state. That's what came up last time as well. Because they're concerned that this legislation is tremendously broad in scope. It would affect rulemaking and health advisories from the Tennessee Department of Health. They list all the agencies. A central problem with this legislation is that in many instances it will establish an insurmountable burden of proof for the agency rulemaking that is out of step with scientific practice. And so these are what these folks warned us about. And again, it's just those concerns still seem to be here, even with the amendment. And so I just was curious if you had worked with any of them or worked with any of the agencies to try and lessen that broad scope that they have raised the alarm about.
Recognize.
Thank you, Mr. Chairman. Section D specifically excludes the Department of Agriculture and the Department of Health. They are no longer subject to the legislation, and it also does not apply to emergency rules promulgated under Tennessee law.
Just ask one follow-up.
Representative Fritz.
Can I ask a clarifying question?
Real quick.
Can you just clarify then, because something's happening with the system, we're getting amendments late. Who would this apply to? Which agencies would this apply to?
You recognize.
I don't really have a broad list, but I know those are excluded. So that's the exclusion that I have because, again, concerns that they both brought.
Representative Fritz. Question been called on the bill. Without objection, we vote on House Bill 896. All those in favor vote aye when the board opens. All those opposed vote no. Mr. Clerk, take the vote.
Mr. Chairman, we have 8 ayes, 1 nay.
House Bill 896 on the floor.
Thank you, Mr. Chairman. And now we are on to House Bill 799 by Chairman Grills. Do I have a motion? We have a motion and a second. Chairman Grills, you're recognized.
Thank you, Mr. Chairman. I have an amendment on this bill.
The drafting code, sir.
5724.
That's what we have. Does it make the bill?
It does.
If you're ready to vote on adding this amendment.
We have a motion on the amendment.
We have a motion on the amendment. We have a second. All in favor of putting the amendment on the bill, say aye.
Aye.
The ayes have it. Amendment goes on. You're recognized on the bill as amended, sir.
I don't need the amendment. TWRA is coming in and trying to tell me from the back I don't need the amendment. We'll put the amendment on because we've already done it.
All right.
Thank you, Mr. Chairman and committee. What this bill does is that creates a opportunity for a commercial guiding license for Reelfoot Lake. Reelfoot Lake's in my district, and there's several duck blinds up there that the state is taking ownership of when people pass away. And what we're wanting to do with these blinds, instead of the state taking control of them and keeping them and having them that you can only use for 3 weeks or 3 days a weekend, is create a commercial blind setting where people can actually continue the businesses that their family have been making a living off of for years. And with that, that's what we're doing.
Okay. All right. We have, I see one hand, Representative Fritz. Previous question has been called. If you're ready to vote, Kirk, please open the vote. Has every member voted? Does any member wish to change their vote? Clerk, please take the vote.
Mr. Chairman, we have 9 ayes, 0 nays.
And House Bill 799 as amended moves on to full committee.
One more. We have several bills that are left on the calendar. All those bills will be rolled to the first calendar of next year. Now we'll be taking up the special calendar. I wish I could have seen his face. This is a special calendar.
Second.
You're recognized, and we'll let you catch your breath.
Thank you, Mr. Chair. I know y'all have had a long day, so I'll have a brief 45-minute presentation for you. Excuse me, no, 45
Representative
seconds.
Shaw, you're recognized for question on the bill. No, you're go ahead.
Thank you, Mr. Chair, members of the committee, for letting me present this.
You're recognized, Representative Hemmer.
This bill modernizes Tennessee's outdated wildlife penalties by increasing fines from their current 1961 levels from $10 to $50 to a maximum of $500 as determined by a judge for all wildlife offenses. And with that, I'm happy to take any questions.
I just put my paperwork. We do not have an amendment on the bill, do we?
No, sir.
Okay. Do we have any questions? We're going to make him wait this long and not ask him a question. Seeing no questions on House Bill 24, we'll be voting on sending House Bill 24 to the full committee. All those in favor vote aye. Those opposed vote no. Mr. Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 0 nays, 2 present not voting.
House Bill 24 on the full committee. Thank you. That's dedication. That concludes the business we have on our special calendar, our full calendar, our special calendar. So I guess that will conclude our business for this part of the 114th General Assembly of the Agricultural and Natural Resources Subcommittee. It's been a pleasure working with you, ladies and gentlemen. Thank you much for the clerks, the legal staff, and all the members that have been here. Representative Shaw will be buying supper tonight. No, I understand. Well, we will adjourn subject call to the chair. I'm sorry. We will close subject call to the chair. Thank you, sir. You have a